Meeting of the first meeting of the General Laws and Technology Committee for the 22 session is called to order here. We'll have everybody, I guess, go on the board for roll call. All right, we do have a quorum here, so we're in business. We will first just pass by for the day a number of bills that different patrons and others have requested be handled that way. And Hobie, would you read off the list of the bills so nobody's waiting around for a bill that definitely is not going to be heard today? So.
Yes, sir. Senator Bell, Senate Bill 312 and Senate Bill 550. Senator Favola, Senate Bill 290. Senator Hanger, Senate Bill 400. I was gonna read them. I was gonna read them twice.
We're on a roll. What do you mean? So.
Senator Bell 312 and 550. Senator Favola 290. Senator Hanger, Senate Bill 400. Senator Lucas, Senate Bill 615. Senator Marsden, Senate Bill 544. Senator Mason, Senate Bill 575. Senator McClellan, Senate Bill 491. Senator Peake, Senate Bill 177 and 179. Senator Peterson, Senate Bill 210. And Senator Suderline, Senate Bill 510. Senator Suderline's is Senate Bill 510.
He's off of that then. Okay. All right. Yeah. Then we also have, so is there a motion to pass those bills by the day?
So moved.
All right. The motion and a second to pass those bills by the day, the ones that were listed. All in favor say aye. Aye. All opposed, no. Those are passed by for the day. Then we have a couple of others in which they've requested that their bill be a bill be stricken. Senate Bill 539 from Senator Peake. He's asked that that bill be stricken. Is there a motion to strike the bill? All right. Is there a second? All right. Any discussion? All in favor? I guess we have to vote on the board. So, yeah. This is strike Senate Bill 539.
Ayes 13, no 0.
All right, 13 to 0. That bill is stricken. Senator McPike, you have a bill to propose action on and striking it.
Yes, Mr. Chair. Striking Senate Bill 606, please.
All right, is a
So
motion?
move. Second.
All right, a motion and a second to strike Senate Bill 606. Any discussion? I guess we'll vote on the board on this as well. So.
Ayes 13, no 0.
All right, that is a 13 to 0. And then we have one request for a bill to be re-referred, and that is Senate Bill 563 from McDougal to be re-referred to the Judiciary Committee.
Second.
All right. There's a motion and a second to refer 563 to the Committee on the Judiciary. All in favor? Vote to make that motion. To take care of
Ayes
that.
13, no 0.
All right. 13 to 0. That bill is re-referred to the Committee on the Judiciary. Now we will take up bills starting with three bills at least that we have from individuals who are members of the Committee on the Judiciary, which is meeting at the same time. So I think I think two people are over there getting checked in on Judiciary and will come here. The third one is Senator Norman. So.
Good afternoon, Mr. Chairman, and ladies and gentlemen. My letter of appearances before you, but it is a pleasure.
You're welcome.
I have Senate Bill 95.
Mr. Chairman,
Yes.
Mr. Chairman, I think the mic might not be working,
Oh.
and we want to hear him.
Senator Bell, be careful what you ask for, sir.
I retract that.
Senate Bill 95, let me preemptively say I hope that no one will immediately assume that this is a partisan-focused bill. It's just that recent administration brought to my attention, I think, a situation that I think from a policy standpoint is probably not good governance. That is not a reflection on any individual that may be impacted by it, just the relationship. The bill is very simple. Basically, what it provides is that the governor's chief of staff, regardless of gender or other persuasion, and a member of the governor's cabinet who is a secretariat appointed by the governor cannot be immediate family members. I'll share with you what brought this to my attention. When I was on the, quote, landing team for the transition, I was asked to participate in the Secretary of the Commonwealth, and candidly, I've had very little direct to do with him over the years. But we did an in-depth analysis, and of course, one thing was very conspicuous that I think all of us were aware of is that the Secretary of the Commonwealth makes recommendations for appointments to all of the public colleges, Board of Visitors, and thousands of other appointments. I learned that the process that is followed on those appointments is that requests are submitted to the Secretary of the Commonwealth, or they do it on their own initiative, but they are then sent to the governor's chief of staff. Well, that caused me to pause just a little bit, but here's the situation that really created some concern for me. And when we were doing the interview process, the Secretary of the Commonwealth very candidly brought up the issue of clemency. And that discussion evolved from clemency to pardons to conditional pardons. And I asked about what the process was on that, and I was told that this was first I'd asked how many were pending, and that was not exactly forthcoming, and that didn't chagrin me at all. But I asked about the process, and the process is that the request for pardons and conditional pardons go through the Secretary of the Commonwealth. That is then referred to the Department of Corrections, who has the opportunity to do any record examinations. Then it goes to the Secretary of Public Safety, who can comment on it. And then it goes to the Parole Board, and they have the opportunity to comment on it. Then it comes back to the Secretary of the Commonwealth, and then the Secretary of the Commonwealth sends it to the Governor's Chief of Staff. My concern was that upon inquiry, I found that in an effort to expedite some of the discretion of His Excellency, who only had a few days left, that the process was not being adhered to, and that, in fact, the request for pardons and conditional pardons was being sent to the Chief of Staff to act upon. I say this, and I don't mean to be disingenuous with it. if we have an administration that is confident and, in fact, is standing firm and not delegating or acquiescing much of the decision-making process to a chief of staff for whatever reason, I think this is a very unhealthy relationship. And so I really do say it ecumenically. While the current situation brought it to my attention, it would be equally applied regardless of any administration. That's the bill.
All right, are there questions or comments from members of the committee? Senator Eben.
Yes, thank you, Mr. Chairman. I did have a few questions for Senator Norman. Wondering if you're aware about the memorandum of understanding that the Attorney General drafted that dealt with a case where a cabinet member was, in fact, a immediate family member of a chief of staff in the last administration. The memorandum of understanding that was in place in that unique situation.
I am not aware of it. Can you share with me, not name-wise, but what the positions were?
Well, you know the chief of staff of the last governor was married to the secretary.
I do. Is that what you're referring to?
Yeah, I'm referring
you
to.
were being a little oblique there. And
I made the inquiry and I found out that there was a memorandum of understanding that the Attorney General drafted for that particular situation so that that cabinet official did not directly report to the chief of staff. Of course, obviously they work together, but I'm wondering, the situation that you described, I don't know enough about the facts to judge it, but could that not happen with any people not following whatever the process is that you were alleging?
I'm trying to be somewhat diplomatic and delicate about this. And first of all, I'm not being argumentative, but I will tell you the memorandum that any Attorney General provides is only the expression of the opinion of that Attorney General and does not carry forward. And that's not meant to be argumentative. It's just like an Attorney General's opinion for those of you that are not attorneys. An Attorney General of Virginia can issue an opinion and it can be persuasive, but the degree of the persuasiveness is only if there is no law to the contrary or any law that expands it. It represents the opinion of that AG at that point in time. And so I don't think a memorandum really is any different, and I don't think it has the portability of going from one administration.
Well, no, I'm not suggesting it does, Mr. Chairman. I'm sorry to interrupt.
But what I'm suggesting to you is that I would like to put it in the law so that we are not relying upon the opinions of any Attorney General, Republican or Democrat, that creates some temporary prophylactic situation.
Thank you.
All right. Are there other questions or comments from members of the committee?
Mr. Chair.
Senator McPike.
I appreciate the senator's willingness to limit the governor's authority. Maybe we had a couple of those debates earlier today about such authority. But in this circumstance, it does sort of, handcuff the governor. Why should the governor not have the ability to have their picks?
I would say to you, Senator McPike, I think that this was a very unusual situation. And I am not trying to bridle or unreasonably constrain the governor on appointments. We can work through that process. I don't recall that we in the General Assembly get into the position necessarily of passing judgment on administratively who the governor may put around him or her. I just think this was a particularly unhealthy situation because these were individuals who not only had a familial relationship, but in fact with one another every day, every night. And I think that we had a strong chief of staff in this situation, and that maybe it was a little bit like osmosis, that where there's a vacuum, somebody is necessarily going to fill that from a governance standpoint. And I don't say that to be disingenuous. I leave it to the will of the committee. I just think it is a better policy if we don't have that kind of relationship going forward. And it is immediate family member. It did not get pervasive on, all family members.
All right.
And you
all right.
notice the administration
Sure.
that
Go
I'm
ahead.
offering this under too. And they have nothing to do with it.
All right. Any other questions or comments from members of the committee?
Mr. Chairman?
Yes, Senator Stewart.
I listened to what Senator McPike said, and I do think, I have voted for people that governors wanted when I didn't particularly care for them, and our ideologies didn't align, and I probably didn't think they were going to do a good job, but I think you have to respect a governor. And so, while I respect you enormously, I think I have to vote against this because I think we have to give governors their ability to make the picks, to have the people to work with them that they trust and think will do the job for them. And I mean, they're elected by the people, and when you're elected overwhelmingly by Virginians, they trust you to pick the people to work by your side that you think will do a good job. Sorry.
All right. Are there other comments or questions from the? Yes, Senator Donovan.
Mr. Chairman, I just, in contrast, and, maybe for consideration of Senator Stewart, I agree in general, but I think the point is in kind of anti-nepotism legislation that we've passed before is that there is a inherent potential for conflict of interest. And I think, protecting for those issues is, a noble thing. And that it makes it important that, the single focus of service is in serving Virginians in the role, which is not to say somebody wouldn't. It just removes any, illusion that that's present or any potential that there could be a problem. So I just think it's a safety check, and I don't think it's unreasonable. But that's my opinion, and I think it's probably why we've looked at legislation and passed it in other aspects of administrative appointments as well.
All right. Any further comments or questions? Yes, Senator Evan.
Very briefly, in today's modern society, we've got a lot of talented people of both genders. And to me, I always thought it was puzzling when you would see that, and I'll name names because they're not Virginia situations, but you would have like a U.S. senator married to a federal cabinet member, or you would have members of Congress of cousins, or uncle and nephew, or even in this body you could have sisters and brothers or brother-in-law or whatever, different relations. And you expect people, we behave in a transparent manner to behave in a transparent manner, and I don't see what the problem was, so I'm going to vote against this.
All right. Is there any further comments or questions from committee members? If not, then are there people in the audience who wish to testify in favor of this bill?
Excuse me, Mr. Chairman, but if you're in the Zoom room and you would like to speak in support of this bill, please raise your hand electronically now.
All right.
Mr. Chairman, there is no one in support of this bill.
All right. Is there anybody to speak in opposition to the bill?
If you are in the Zoom room and you would like to speak in opposition of this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. All right. There's no public speakers either for or against the bill. Is there a motion to be made by a member of the committee?
Mr. Chairman,
Yes.
I move that the bill be approved. I think that Senator Norman has brought up an issue that's kind of in the clouds out there. It's not good to have a supervisor somebody under a supervisor who is a spouse. I think it's just bad public policy. It looks bad.
All right. Senator Evans.
Substitute motion to PBI.
All right. We have a motion to pass by indefinitely. Is there a second to that motion? right, motion is to pass by indefinitely. It's been moved and seconded. Is there any further discussion? All right, we will vote on the board then, so.
This is the PBI?
For pass by indefinitely, yes.
Ayes 7, noes 8.
All right, ayes 7, noes 8. The motion fails. Is there another motion to be made?
Move to report.
Go back to the primary motion, that's right. The primary motion is to approve the bill, recommend adoption of the bill. Is there anything, any further comment? All right, we will vote on the board.
Ayes 8, noes 7.
All right. All right, the motion passes.
Mr. Chairman, again, I would say I have no malice in thought or in my heart on this, and if you think that there is some language that would improve it and temper it, that doesn't undermine the entire integrity of the bill, I am receptive to it. This really is strictly a policy issue with me, and I
Understood.
appreciate
And thank you very much for presenting it that way.
your
So,
courtesies.
all right, we have two others who are members. All right, calm down here. So. The first session.
All reaps.
Yeah. All right, we have two others who are members of the Committee on Judiciary that we'll take next, Senator McClellan first, and then Senator Morrissey.
Thank you, Mr. Chair. I have Senate Bill 494, which makes 3 changes to the employment discrimination provisions of the Human Rights Act. The first one is one that I think makes the definition of an employer consistent, regardless of whether an employee is fired or not. Under current law, the definition of an employer is 5 or more employees if the employee has been fired, but not if the employee has been harassed to the point where they quit or harassed unlawfully yet not fired. There really is no public policy justification for that. It is also very confusing to both employees and employers, particularly if you have an employee who wants to bring suit under this. They first have to figure out how many, was I fired or not, and if so, which one applies. And it just doesn't make any sense. So that's the first change. The second change provides a 2-year statute of limitations for filing a discrimination charge, which is a clear, consistent statute of limitations, consistent with the statute for tort law. And I would say that it usually will take some time, particularly if you've been fired. If you're a low-wage worker, your first priority is to find a new job. If you have been sexually harassed or harassed to the point where there is emotional distress, you probably need some time to come to grips with the trauma of what happened. And then finally, it would make the award of attorney's fees mandatory instead of discretionary for a plaintiff that prevails. This is consistent with federal law, where the Supreme Court has ruled that under the federal laws, even though the word may is used, that for employees that have been unlawfully discharged, attorney fees must be rewarded for prevailing plaintiffs. And that is the bill.
All right, are there questions or comments from members of the committee? All right. Is there anyone who wishes to speak in favor of this bill?
If you are in the Zoom room and you would like to speak in favor of this bill, please raise your hand electronically now. Mr. Chair, we have multiple names. Mr. Jonathan Gallus, you will be going first.
All right, proceed.
Hey there. Can everyone hear me?
Yes, we can hear you. Please.
All right, thank you. Good
provide
afternoon,
your-
Mr. Chairman and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We are wholeheartedly in support of this bill as a measure to provide needed consistency within the Human Rights Act, and particularly clear pathways to civil remedies for those who experience workplace harassment and discrimination. As many of you know, we represent Virginia's 67 sexual and domestic violence agencies across the state and operate a 24/7 crisis hotline on behalf of those programs. Throughout the pandemic, our hotline has experienced a notable uptick in the number of callers who are reporting severe harassment at the hands of an employer. And many of those callers have had no choice between, or have had to choose between unsafe and even traumatizing working conditions versus the uncertainty of joblessness, housing insecurity during an already unstable time. So for many survivors of sexual and domestic violence who are ready to leave shelter and attempt to become self-sufficient after their abuse, these working conditions can force them to choose between their freedom from abuse or returning to an abusive relationship, re-entering shelter, etc. We think this is good policy for survivors of violence, but also for Virginia businesses, and we hope it's the will of the committee to vote yes on this measure. Thank you.
Thank you. Is there another speaker?
Mr. Mark Hanna, you will be next, followed by Sheila Varkey.
Good afternoon. My name is Mark Hanna. Can you hear me?
Yes, we can hear you. Please proceed.
I'm an attorney in Annandale and a partner in a public interest law firm called Murphy Anderson PLLC. I have over 20 years of experience representing thousands of employees, many of whom were victims of civil rights violations, including sexual harassment and racial discrimination. In 2020, the Virginia Values Act, the legislature made important changes to the civil rights law. Unfortunately, the legislature included some contradictions and inadvertently left out a few critical details in enacting that really important law. The minor changes proposed in SB 494 fix 3 technical problems. It does not include any new cause of action. The Virginia Human Rights Act currently has uniquely convoluted and problematic language in regard to which employers are covered by the act. Unlike most state civil rights laws that simply state a blanket employer size threshold, in an entire civil rights law, the Virginia law has different thresholds for different acts of discrimination and different protected categories of employees. This is simply too hard for employers, employees, and the administrative agency to work out. With respect to the statute of limitations, the Virginia Values Act was passed without a statute of limitations. It simply states the action must be filed timely in a timely manner. This has created confusion for victims, for employers, for the courts, and for administrative agencies. I strongly recommend that we include a modest 2-year statute of limitations, which gives low-wage employers just enough time to file a claim. And with respect to attorney's fees, Virginia employees, particularly low-wage workers, have difficulty finding competent counsel to represent them in discrimination claims. One of the reasons is this language is permissive for a court whether or not they give attorney's fees. While we expect that the Virginia Supreme Court will find that this mirrors federal law and that for prevailing claims, all attorney's fees must be paid, we don't want to leave a question, and we want this law to be consistent with other civil rights laws and other employment laws in Virginia, which use the word shall, including other laws passed by the legislature in the last few years. I strongly support this bill and am happy to answer any questions with respect to how this law should be passed. Thank you.
All right, thank
really
you.
Appreciate your time.
Yes. Sure, we can try it here. So,
Sir, to the gentleman who just testified, if you could just delve in one more time to the part about the notice about the 2-year statute of limitations, that without, or maybe I should ask actually I'd rather ask counsel, without the change to the 2 years after the alleged discriminatory practice occurred under our without that change, what is the current status of the law for complaints?
I'm happy to answer that. Right now, we don't know. The Virginia administrative agency in charge of it is saying that it could be a matter of days to file an administrative claim. And the time and various courts will interpret it in different ways. We're having a lot of trouble with respect to determining what an adequate statute of limitations based on the very vague word timely. 2 years is consistent with other states and is just enough time for, especially for low-wage workers.
Okay, thank you, Mr. Chairman.
All right, thank you. Next speaker.
Sheila Varkey.
Good afternoon. Good afternoon, Mr. Chair and members of the committee. I am Sushila Varkey, and I am a domestic and sexual violence attorney at Virginia Poverty Law Center. And I support this bill, as does VPLC, for low-wage workers. The confusion that arises from having a 5+ employee versus 15+ employee for different discrimination charges makes it harder for a low-wage worker to determine what their choices are in those types of circumstances. And especially for low-wage workers, they are looking to, as many people are who are struggling, they're looking to each paycheck to cover their bills, rent, etc. If they're dealing with a termination, etc., they may need some more time, which a 2-year statute of limitations would provide to them to determine what course to take. Thank you so much.
Thank you. Next speaker.
Andrea Johnson, you are speaking now.
I'd like to cede my time to Lee Strelka, who I understand was having some difficulties getting into the room, but is online.
Proceed, please.
Andrea Johnson, can you say the name again?
Lee Strelka?
Okay.
Thank you, and sorry.
Which one I do?
Lee Streichel, you can speak now.
Hi. Hello, my name is Lee Strelka. I'm a partner at Strelka Employment Law in Roanoke, Virginia. As an attorney who regularly assesses these types of cases, as currently written, the law is confusing for attorneys to help victims navigate the law because of the distinction between the discriminatory discharge and the employer threshold. The lack of clarity related to the statute of limitations is also a very big problem for us. And so if these issues are confusing for someone with a law degree like myself, it's probably compounded for somebody who doesn't and is trying to figure out how to navigate their rights. So from our perspective, this will cause greater costs for employers and employees alike. And so that's why we support this bill. Thank you.
All right, thank you. Is there anyone else who wishes to speak on this bill?
If you are in the Zoom room and you would like to speak in opposition of this bill, please raise your hand now. Mr. Chairman, there is no one wishing to speak in opposition.
All right, thank you. The bill is before us now. Yes, Senator Eben.
I just want to thank Senator McCollum for identifying something. I sponsored the original Virginia Values Act with her and Senator Boysko, and we thought we did a pretty good job, but the precision of the having to file the complaint in a defined manner particularly is important. So I want to thank her for bringing the bill, and at the appropriate time, I have a motion.
Mr. Chairman.
Yes, Senator Ruff.
I applaud the efforts of the patron, but our small businesses, our really small businesses that have just a few employees, are struggling all the time. And the threat of a lawsuit that they would not be able to go to court on, they would have to settle out of court, would mean that they would be put in a much worse situation. So I cannot support the bill.
All right, Senator Stewart.
Thank you, Mr. Chairman. And to pile on to what Senator Ruff just said, you notice this bill on line 209 orders attorney's fees for the plaintiff, yet there's no reciprocity for the defendant. And I don't claim to know all there is to know about the code, but there's only one other place that I know that you can get attorney's fees where they're not reciprocal and they're not ordered. This bill actually says shall pay attorney's fees just to the defendant, but no reciprocity, just to the plaintiff and no reciprocity to the defendant, which, really puts a small business of 5 employees at a disadvantage, and almost couldn't even afford to defend a suit like this. And that's pretty scary to me. So I'm going to have to vote against it.
All right. Is there anyone else that has any comments or questions? You want to sum up anything, Senator McClellan?
Yes, I would. On the point that you just raised, reciprocity of attorney's fees is not standard for civil rights violations. And by having mandatory attorney's fees for a prevailing defendant really puts a chilling effect, particularly on low-wage workers, in bringing these claims to begin with, which is why reciprocity is not standard. But under federal discrimination law, the Supreme Court has already said that plaintiffs shall be awarded, successful plaintiffs shall be awarded attorney's fees in a prevailing case. To Senator Ruff's point, employees, small businesses with 5 or more employees are already subject to this law. The question here is, what is the public policy rationale that if you are an employee who is pregnant and denied an accommodation or fired, whether you can bring a claim, whether your employer is an employer, is yes, and it's 5 or more. That same employee, if they are sexually harassed, demoted for rebuffing an unwanted sexual advance, or otherwise discriminated against, there's a different standard. There is no public policy reason for that. And small businesses of 5 or more employees are already subject to this law. We're not changing that. We're just saying an employer is an employer whether they fire you, which is 5 or more, or whether they demote you for refusing an unwanted advance that violates this act or any other action short of firing you.
All right, thank you. Is there anyone wishing to propose a motion?
Mr. Chairman, I would move to report.
Second.
All right, it's been moved and seconded to report the bill. Any further discussion? All right, we will vote on the board.
Ayes 8, no 7.
All right, the bill is reported.
Thank you, Mr. Chair.
Thank you. Senator Morrissey.
Good afternoon, Mr. Chairman, members of the committee. Mr. Chairman, I'm before you on Senate Bill 409, which is occupational licensing reform. What I would like to do at first is may ask that somebody move 2 amendments. One is line 74, strike upon clear and convincing evidence. And the second one is line 77, replace and with because.
Does staff have those amendments, those line amendments?
Mr. Chair, we have released them to be posted online. It might just take a minute or 2.
All right. Does anybody want to make a motion to adopt these?
Second.
All right, we have a motion and a second to adopt the amendments. All in favor say aye. Aye. All opposed, no. All right, proceed.
Thank you, Mr. Chairman. Mr. Chairman, my bill today revises current law regarding occupational licensure for people with a criminal record. The bill's purpose is very simple and straightforward. It's to help men and women who have been incarcerated or convicted of a crime and have demonstrated significant rehabilitation to be able to get back to work. When, as many of you know, when Virginians with a criminal record make the decision that they are going to follow the straight and narrow and leave the criminal bad choices behind, a key contributor to them being successful is being able to get a job and meaningful employment. Unfortunately, some of these people often struggle in both the private and public sector with finding employment. And one of the principal hurdles that they need to overcome is in the area of occupational licensing, where applicants with criminal records can just experience extensive and drawn-out review process. When we're talking about those individuals get occupational licensing, it's over 50 different groups, from auctioneers to barbers, cemetery salespersons, cosmetologists, contractors, gas fitters, hearing aid specialists, HVAC technicians, on-site sewage system folk, real estate brokers and realtors. There's over 50 people that and professions that are regulated. This, what this bill does is it, while Virginia does not bar people with criminal records from getting the regulated occupation, we need to eliminate the unnecessary delays and allow them to get that. So what this bill will do is as follows. Currently, a person who applies for an occupational license must disclose past convictions to the Department of Professional Occupational Regulations. That's not going to really change at all. But that person that discloses it has to go through what's known as an informal fact-finding conference. It's known as an IFF, where the board will decide whether the person's criminal history is related to the job that they seek licensure. And according to DPOR, and I should say that the folks that I worked with DPOR on this bill. According to DPOR, this additional review process is very lengthy, and it can take several months. Imagine an individual who's trying to get one of those occupational licenses that I just spoke of, and they go in the interview on Monday or Tuesday, and they hope to get a notice on maybe by the following week that they're hired, but it's going to take them 6 months to go through the process. It can often prevent them from getting that job. I would also add this, in the vast majority of these IFF, informal fact-finding conferences, the license is going to be granted at the end, meaning that in most cases the applicant's ability to work was just needlessly delayed. So we need to remove these unnecessary delays in circumstances where it is clear that they no longer, the individual provides or promotes a danger to the public. So my bill simply addresses this need by eliminating the review of certain offenses where the applicant has proven that he is desirous of leading a law-abiding life. So the board will no longer consider misdemeanors if 3 years have passed since the conviction without a subsequent offense. In other words, it's no longer necessary to go through the IFF process if it's a misdemeanor conviction. They are desirous of getting a job in the field of plumbing or electrician or on-site sewage system, and there's been 3 years since that last offense. Nor will they consider nonviolent felony offenses that has had a 7-year hiatus between the last time they committed any type of offense. And under this bill, boards would not deny a license solely because of a criminal record unless the offense directly relates to the profession that they seek. And second, the applicant has not rehabilitated himself in a manner that would allow him to engage in that profession. Lastly, the bill ensures that people who are denied licensure due to their criminal record are notified of the crime's relationship to the job that they seek. So, Mr. Chairman, members of the committee, in closing, I want to note that this bill speaks to two very important goals in the Commonwealth that I think is not nonpartisan goals. Successful reintegration of people with criminal records into society. And number two, we're experiencing right now the shortage of workers in certain skilled fields. So I'm asking that you remove these unnecessary delays and that allow people who are desirous, have shown rehabilitation, to be able to engage in these professions. Thank you for your time, Mr. Chairman. I think there may be some folk pro, I don't know if there's any con, and I don't know if there's anybody in the audience that is also, I think there may be one or two people to speak.
Yes, thank you, Senator. Question, Senator Eben?
Just wanted to thank Senator Morrissey, but I really just had a point more than a question. Line 73 to 77 seem to indicate that the regulatory board will still assess senators. So if, for example, if someone was convicted of embezzlement and they were applying to be the, I don't know, a financial board that would allow them to be a CPA or something, presumably that would raise the eyebrows of the regulatory board and that person, unless they were supernaturally rehabilitated in a way that demonstrated that they could handle money with great trust, would presumably be disqualified from perhaps that one license.
Senator Evans, very pressing, and I'd point out that what has to happen is that the board would not deny a license simply because the person has a record unless, one, as you just pointed out, the offense directly relates to that occupation and the applicant has not rehabilitated himself.
Yeah, thank you, Mr. Chair. If I might,
the conjunction and is
I just wanted to underscore, I had a constituent when I was going door to door years ago whose son was denied a contractor's license because of a marijuana possession, which was unrelated from years before. So I think this gives people a chance to support themselves and not rely on state aid if they can acquire a good skill. So thank you.
All right. Senator Ruff.
Senator, you indicated that after that lengthy 6-month process, few were rejected. Do you have any numbers of who or what percentage are rejected?
The person that followed me will have those numbers, but it's a very, in my preparation for this, I was told it's a very, very, very negligible amount of people that fail the IFF process. And that process, I mentioned 6 months, it could be up to 6 months, but the young lady that's following me will address that question.
All right. Are there any further comments or questions? Yes, Senator Donovan.
Thank you, Mr. Chairman, and Senator Morrissey. I caught the amendment on 74. What was the amendment on line 77?
77 strikes the word and substitute because.
Okay, thank you.
All right. Any further questions or comments from the? Yes, Senator Stewart.
Thank you, Mr. Chairman. Senator Morrissey, I'm just trying to understand who this applies to. So at line 31, it would be the state bar or the Board of Bar Examiners. Explain the difference to me with those two. What implication does this have on lawyers because you have the Board of Bar Examiners?
None.
So why do we have the Board of Bar Examiners in here?
It doesn't affect either doctors or lawyers. Let me read line 31 again.
So are you only intending this to affect those regulated by DPORS, which
Yes, sir.
would be the contract trades?
Yes, sir.
I have no problem with that, but this seems to go farther, or maybe I just don't understand it, because this covers the Board of Bar Examiners, the Department of Professional Occupational Regulation, and the Department of Health Professions. And if you're talking about lawyers and doctors, that does give me a little bit of pause.
It does not include them, and I'm going to let the person standing right behind me address that, okay? And you're directing the folks to line 31?
Well, I may listen to you more than Preston.
Yeah. I asked that specific question.
Or whoever it is.
Senator Stewart, and it does not, this bill has no effect on the legal profession or the health profession.
Just DPOR.
Yes, sir.
Okay, thank you.
Mr. Chairman, if I could offer a little bit of assistance here.
All right. Yes, staff, please.
Okay, thank you. So I just wanted to point out that this section that is being discussed currently only requires those agencies to do a biennial report, which they're already required to do. This adds that they have to add certain things to that biennial report regarding criminal convictions, but it doesn't also require the health professions and the Board of Bar Examiners to make those findings, such as the IFF, of which the Senator has been speaking, that are required in the next section. So the next section only applies to DPOR.
All right, thank you. All right, any other comments or questions from the committee members? All right, is anybody from the public to speak on this bill?
If you're in the Zoom, please raise your hand electronically now if you would like to speak in support of this bill. There is no one wishing to speak electronically in
All
support.
right, is there anyone in the audience who wishes to speak in support of the bill? Yes, come forward, please. Senator?
Yes, I'm sorry, excuse me.
Good afternoon. My name is Angela Inglet, and I'm here on behalf of Prison Fellowship, which is the nation's largest Christian ministry to prisoners, former prisoners, and their families. And I am here today because we believe that society should celebrate when people with a criminal record work to contribute to their communities, support their families, and strive to meet their full potential. And this bill celebrates those accomplishments by ensuring that our occupational licensing laws acknowledge this real change when it occurs. And it does that by centering rehabilitation within the licensing process and by removing the consideration of old misdemeanors and nonviolent felonies. We believe that in a just society, laws are to be tailored to effectively punish crime, but to still recognize the God-given potential of people with a criminal record. And we believe that this bill reflects that delicate nuance. And so I'd like to thank Senator Morrissey for working with us on this legislation and ask the committee to pass this legislation. And in closing, I would like to address, Senator Ruff, your question. I don't have the specific number, but I believe it's somewhere in the 80 percentile of folks who go through that IFF process are approved in the end. I can send you DPOR's biennium report, which includes that number, but I believe it's about in between 82 and 83%.
Yes, Senator Ruff?
Are approved.
Clarify, 20% rejected.
Are rejected, yes,
Okay.
roughly. Mm-hmm.
That's slightly more than you led.
All right, thank you. Any other questions or comments? Anyone else to speak in favor of the bill?
Mr. Chairman, members of the committee, I'm Preston Bryant of McGuire Woods Consulting on behalf of the Associated General Contractors. Our board looked at this bill as recently as just a couple hours ago and came out strongly supportive of it. They looked at the language that says it directly relates. They looked at the time lapses after certain convictions and assuming no additional troubles, and the construction industry feels that they could be, as a community, very helpful to folks in these circumstances and provide good paying jobs. So they actually very strongly support the bill.
Thank you. All right, is there anyone else to speak in favor of the bill? All right, is there anyone to speak in opposition to the bill?
If you are on the Zoom and would like to speak in opposition of the bill, please raise your hand now. Mr. Chairman, there are no speakers digitally.
All right, do you want to come speak in opposition? So, Joe? Senator?
I have no further comments.
No, wait.
Oh, excuse me.
Do you want to take that?
I'll take this out of your way. Go ahead.
Good afternoon, Mr. Chairman. I'm Catherine Hill. I'm with the Board of Bar Examiners. I'm the Secretary-Treasurer for the Board of Bar Examiners. The board has asked me to appear to oppose the bill to the extent that it interferes with the board's authority as a judicial branch agency to ascertain the qualifications, including the character and fitness of applicants for licensure to practice law in Virginia.
All right. Staff, can you comment on whether the issues that Senator Morrissey has raised in this bill would apply just to DPOR or to the bar examiners and the health professions?
Thank you, Mr. Chairman. And to your question, I would like to get back to you about that, just to confirm that this does apply to the Board of Bar Examiners. I can see it being read broadly as including any regulatory board may include the Board of Bar Examiners, but if I could have a little bit of time just to confirm that.
All right.
Mr. Chairman. Mr. Chairman.
Senator Stewart.
I read it that way too, and I also read it as including medical professionals,
Right.
so lawyers and doctors, and that is what gave me pause. This is a great workforce bill, and I think that's what the senator's trying to do, is just a workforce bill for those trades that are regulated by DPOR. So I don't know, Senator Morrissey, would you consider it a friendly amendment if we just tried to limit it to those professions regulated by DPOR?
So I would consider it a friendly amendment, and I do. And I would also say this, that somebody that is going before the Virginia Board of Bar Examiners, it's different than the VSB. It's a lengthy process. You submit a voluminous documents, and it is much more thorough than an IFF. So I'm not quite sure what the young lady was speaking about, but I still consider it a friendly amendment.
Mr. Chairman, then I would make, I guess, an amendment in concept that hopefully the staff could figure out to just limit this to the professions or trades regulated by DPOR.
Second. All right. We have a motion that would be to limit the provisions, particularly starting in line 66 through basically the rest of the legislation that would apply only to DPOR and not to health professions or the bar examiners, as they are still providing a biennial report, but would not apply to this section of it. There.
Mr. Chair?
Yes.
And to Senator Stewart, if you look at line 66, this language change only applies 54.1-204 to DPOR, whereas the comments dealing with the Virginia Board of Bar Examiners is the biennial report.
Right.
But to the extent that Senator Stewart wants that additional reassurance, I still consider it a friendly amendment, albeit not necessarily a necessary one.
Thank you, Mr. Chairman. Senator Morrissey, I appreciate that. I think there are a few people, at least on my end, who had questions about that, and we like your bill as a workforce bill, and we'd like to be able to support it. So that lets me support it with that amendment.
All right.
Mr. Chair?
We need to vote on the motion.
Mr. Chair?
Yes.
Before we move forward, I'd just like to say I don't understand why we are not opening this to people who have rehabilitated themselves and who have shown themselves to be worthy of working. If the patron wants to accept the amendment, I respect that, but I mean, if somebody has really proven themselves, we want them to be successful wherever they are.
All right. The motion that's before us right now is to we're adopting a concept is to have the prior convictions not to abridge rights section that starts on line 66 apply to DPOR and the people applying for licenses through them, but not for health professions and the bar examiners, which were on the biennial report prior to that. So, all right, is there the motion is before us? All in favor, say aye. Aye. All opposed, no. All right, that motion is adopted, and staff will work on that and give us language that we could take to the floor then. All right, Senator Ruff moves the report as amended, and there's a second. Second. All right, is there any further discussion? All right, we will vote on the board then.
Thank you, Mr. Chairman. Thank you, members.
15-0.
All right. We have one more bill as a Judiciary Committee member. Senator Deeds, would you come up, and then we'll get to Senator Hackworth, Senator Chase, and Senator Lewis. So your time is coming. So.
Thank you, Mr. Chair. I've got Senate Bill 308.
308, Senator.
308 is a product of the last Secretary of the Commonwealth's office. It was intended to be a cleanup bill for board appointments. It updates the length of several boards to allow memberships to begin on the 1st of July and end on the 30th of June. It staggers memberships, so only half the memberships roll off at a time. It affects a bunch of boards that are laid out in the code section: the Horse Industry Board, the Potato Board, the Sheep Industry Board, the Aquaculture Advisory Board, the Marine Products Board, the Virginia Commission for the Arts Board, for State Emergency Medical Services Advisory Board, the Board of Visitors for Mount Vernon, the Board for Asbestos-Lead and Home Inspectors. It makes membership update requirements for the Board of Asbestos, Lead, and Home Inspectors within the within DPOR, by changing the membership from 14 to 13 to avoid tie votes. It adds one licensed home inspector and removes the licensed innovator and dust sampling technician. It's a momentous bill.
All right. Does anybody have any momentous questions to ask the patron? So, all right. All right. Is there anyone to speak in favor of the bill?
If you're in the Zoom room and would like to speak in favor of the bill, please raise your hand electronically now. There is no one wishing to speak in favor.
All right. Anyone in the audience wish to speak in favor of the bill? All right. Is there anyone in the audience who wishes to speak in opposition to the bill?
If you are in the Zoom room and would like to speak in opposition of the bill, please raise your hand electronically now. There is no one wishing to speak.
All right. All right. There's a motion and a second to report the bill. Any further discussion? All right. We will vote on the board.
That's 15, no zero.
All right. It passes unanimously.
Thank you very much.
All right. Senator Hackworth, welcome.
Thank you, Mr. Chairman and members of the committee, and good afternoon. Senate Bill 121 basically is a revision of the Virginia Code 54.1-1101, which allows individuals to provide certain construction services that do not require an individual license or certification from DPOR, provided that work is valued under $5,000, and that includes material and labor, and performed, and the key word is on behalf of a licensed residential commercial home improvement contractor. And the purpose of this statute was to remove barriers to well-paying entry-level construction jobs, which at the time required an individual license or certification. And these services includes framers, masons, drywall installers, flooring installers, painters, other trades of the nature. It does not include highly technical trade work such as plumbing, electrical, HVAC, gas fitting, water well systems, elevators, accessibility, anything that requires certification for the kind. And according to a Harvard University Joint Center for Housing Studies, the average hourly wage in residential construction industry rose to $32 an hour in the middle of 2021. And if anybody has done any construction projects in the last year, you know that material cost and labor has went through the roof. Being a contractor and in this business, we have seen some materials go up as much as 200% if you could get them. So this was amended in 2017. I think it started in 2017 to 2,500. Right. Then it went up to 5,000 in 2018. Well, 2022. In speaking with the Home Builders Association and different ones, we feel like that raising that limit to 25,000 is where it needs to go. And basically, this is to try to get more labor and to help with the housing crisis and the labor shortages here in the Commonwealth. So I also have Mr. Andrew Clark here to speak on behalf of this, and I would yield the rest of my time for him.
Mr. Chair.
Yes,
I'm sorry.
Senator McPike.
typically, quick question, is this your first bill presented?
It is my first bill, and I would like to see a unanimous
So,
green board.
You opened yourself for that one.
Thank you, Senator McPike.
All right.
Mr. Chairman?
Yes, Senator Stewart.
Senator Hackworth, do you have any concerns about letting unlicensed people do all that work?
So if you, and that was one question that was raised, and these individuals are acting in behalf of a licensed contractor. So they cannot go out and just do work by themselves. So if you contracted
Mr.
me.
Chairman, so does that mean that they're going to be standing there watching them to make sure they do it okay?
Well, their license is on the line, so they better be.
But I mean, so you could actually have people who aren't qualified to do the work do this?
Well, we're talking about, framers, tile setters, floor installers. So I would hope that each contractor, knowing that they would have, that they carry the liability policy for those.
Anybody going to help me here, or are you just going to let me do
No.
this myself?
Well,
We're not gonna
Senator Stewart, I would say that that when they came to talk to me, they said anything that I could do or you could do would be in this category. So.
Yes, toting lumber, Senator Stewart.
Thank you. That's all the questions I have.
Mr. Chairman,
Yes, Senator Bell.
I have a question. When was the last time this was raised, and how does that match with inflation? How much inflation's gone since then?
It was last raised in 2018. I can tell you, Senator Bell, that last year we had 3/4 subfloor Vantec plywood that was selling at $30 a sheet, and it went up to $100 a sheet. So nominal lumber, studs went up 200%. So $5,000. I mean, you can't even walk out of Lowe's with one buggy of lumber to do a deck for less than $5,000. So that's why that we felt like that this was long overdue, and especially when you put the labor factor in there, it just cannot.
Mr. Chairman, I commend the gentleman for even attempting public math.
All right.
Mr. Chairman.
Senator Reeves.
Senator Hackworth, can you explain why we went from project, I think, where is it? Where's the line? Project to unit. Why is that?
I will let Mr. Clark answer that question. Senator Reeves.
All right, I think this one's yours.
So, Senator Reed, that is a technical question that is best answered by a professional that is above my pay grade.
Mr. Clark.
It doesn't matter. I mean,
all right, Senator Locke.
Geez, I knew this was coming.
Senator Hackworth on lines 33 through 35. You said it indicates that any person who performs or supervises the repair or improvement of residential dwelling units owned by him that are subject to the Virginia Residential Landlord and Tenant Act. Are you familiar with what the Virginia Residential Landlord and Tenant Act includes, and why are you putting forth legislation that goes counter to that?
I am not, ma'am.
This legislation appears to do that. And why would we approve something that would go counter to that legislation?
Because I'm the best looking senator on that side.
Now that I'll agree with.
All right. We will proceed now, and we'll save the rest of this till you get to the floor. So
more.
Thank you.
All right. Mr. Clark. So.
Andrew
You're next.
Clark. Right, Andrew Clark with the Home Builders Association of Virginia, and after that rigorous questioning, we support the bill and thank the patron for bringing it, and happy to answer any questions or pass it to the senator.
All right. Next.
Good afternoon, Mr. Chairman. Randy Grumbine, represent the factory-built housing industry. We too support Senator Hackworth's attempt to broaden the pool for workers. Thank you.
Thank you. All right. Is there anybody on the line that wants to comment either for or against?
If you're in the Zoom and you'd like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there is no one wishing to speak in support.
All right.
Mr.
If
Chairman.
you are in the Zoom and you would like to speak in opposition of the bill, please raise your hand electronically now. Mr. Chairman, there is one speaker, Mr. Jason Parker.
All right. Proceed, Mr. Parker.
Thank you for taking me, Mr. Chair and committee. Jason Parker, Virginia State Building Trades. We oppose this legislation. We think it opens up a lot of money towards misclassification of workers. Thank you.
All right. Is there anyone in the audience who wishes to speak in opposition to the bill? All right. Is the bill's before us? Is there anyone who wants to make a motion?
Mr. Chair,
Yes, Senator McPike.
I do have a motion in the nature of an amendment, which would be to strike unit and restore project. And I know that cuts the Good Senator's bill in half, but I think define unit in the code is not as more readily defined as project would be and utilized in common language.
We would consider that a friendly amendment.
All right, there's a motion to. We have a motion and a second to, on line 49, strike unit and reinsert project. All in favor say aye. Aye. All opposed, no. All right, that amendment's adopted. All right, the bill is before us.
Move to report as amended.
Substitute motion, move to PBI.
Second.
I'll withdraw my motion, Mr. Chairman.
All right, we have a motion to report. Is there a second to the motion? All right, and the PBI motion was withdrawn before you finished saying what it was, what it was going to do. So, all right, we have a motion to report the bill. We will vote on the board.
One.
All right, report the vote.
Ayes 14, noes 1.
Ayes 14, noes 1. The one assures that you will have to defend this on the floor of the
I
Senate.
know exactly what that was. Thank you.
All right, Senator Chase.
Thank you, Mr. Chairman and members of the committee. Would you like me to begin with Senate Bill 582 or Senate Bill 548?
Either way you want to go.
Okay, wonderful. Thank you. We'll start with Senate Bill 582, which is a bill that is a freedom of choice bill and a freedom to breathe bill. This has to do with making sure that we do not discriminate against individuals who cannot or are not able to wear masks. Mr. Chairman, I'm going to take a moment to read specifically who this affects. This bill prohibits discrimination in places of public accommodation, including public and private elementary and secondary schools and institutions of higher education and certain private establishments, because the individual is or is not wearing a face covering for the purposes of preventing the transmission of COVID-19. Mr. Chairman, this is not an argument of whether we should wear masks or not. This is simply, or whether masks are effective or not. This is giving individuals the ability to exercise that freedom. Currently, we have a one-size-fits-all approach, and not everyone can actually wear a mask. We have individuals have developmental and intellectual disabilities. We have individuals who are victims of domestic violence, many of whom are strangulation victims, and wearing a mask is an impeding factor. We also look at our young children and their developmental issues as well. And I would like to bring attention in this bill to the Executive Order 2 that the governor just issued. And how it says that there's no greater priority than the health and welfare of Virginia's children. And under Virginia law, parents are not the government, have the fundamental right to make decisions concerning the care of their kids. And we just had this executive order issued. And in there, it talks about that as parents and educators observe, many children wear masks incorrectly, providing little or no health benefit. The masks worn by children are often ineffective because they are made from cloth material and they are often not clean, resulting in the collection of impurities, including bacteria and parasites. Additionally, wearing masks for prolonged periods of time, such as for an entire school day, decreases their effectiveness. Masking may be more or less effective depending on the age of the child. At the same time, that a universal masking requirement in schools has provided inconsistent health benefits. The universal requirement has also inflicted notable harm and proven to be impractical. Masks inhibit the ability of children to communicate, delay language development, and impede the growth of emotional and social skills. Some children report difficulty breathing and discomfort as a result of the mask. Masks have also increased feelings of isolation, exacerbating mental health issues, which in many cases pose a greater health to children than COVID-19. 2 years into the COVID-19 pandemic, mask mandates in schools have proved demoralizing to children facing these and other difficulties. While the Center of Disease Control recommends masks, its research has found no statistically significant link between mandatory masking for students and reduced transmission of COVID-19. And the CDC has acknowledged that certain masks may be ineffective due to the material from which they are made or how they are worn. A review of CDC, WHO, and other local and international health authorities' recommendations reveals a lack of consensus on the cost and benefits of mask wearing for children in schools for many of the reasons noted above. In light of the variety of circumstances confronted by students in the Commonwealth, parents should have the ability to decide whether their child should wear masks for the duration of the school day. This approach is consistent with the broad rights of parents. Masks are not the only method to reduce transmission of COVID-19. Local schools must ensure they are improving inspection, testing, maintenance, repair, replacement, and upgrades of equipment to improve their indoor quality. And many of these are quotes from the executive order too, which is also encompassing. Now, my bill encompasses more than just the children, so let me be very clear on that. This bill, whenever we talk about places of accommodation, we're talking about all places or businesses offering or holding out to the general public goods, services, privileges, facilities, advantages, or accommodations. So I want to be very clear. We're talking about a number of individuals. You know, one of the things that concern me is that we have people who have disabilities who cannot wear the mask. We have children. We have many different reasons why people are unable to wear the mask. And so we need to make sure that we allow individuals that flexibility to exercise that discretion. One last thing that I will leave you with is that if you actually look at a box of COVID-19 masks, the manufacturer has actually printed on the mask, the paper mask that you see, not the N95 mask. It actually says does not protect against viral infections. Even the manufacturer has deemed these paper masks as ineffective against the spread of COVID, and yet children across the country and across Virginia are being forced to wear these cloth and paper masks. I guess one of the final things that I would just say is that while we have many opinions about whether to wear masks or not, it should be an individual right. It should be an individual choice. I remember a period of time whenever that was not necessarily an option, and it impeded people who had disabilities from actually getting health care services because they could not wear a mask, not being able to go to the grocery store and shop. We cannot deny people a basic human right of getting and being provided health care and basic services. With that, Mr. Chairman, I do believe I have a number of speakers that are in the queue. If they're still there from earlier, I would like to defer the rest of my time to those individuals.
Is there a question? Senator Eben.
Thank you, Mr. Chairman. I just want to be clear on what could happen or on what you mean by this. So under this bill, if it was to pass, would you have the right to come into my private establishment, maybe with very few workers who are available and need to stay healthy, and maybe even a medical establishment, and possibly sneeze on me without a mask when you're positive for COVID? Is that possible that that could happen?
What I would tell you is that, we would never discriminate against anyone who has a disability. I know from personal experience.
Communicable disease.
And what I'm telling you, if you'll let me finish, please, is that a lot of times people will call in advance to their healthcare provider and they will actually wait in the car until it is their time to be seen by a doctor, in which they are taken in the back door to that facility. So there are accommodations that are made to avoid situations like the one in which you are speaking.
One follow-up.
Senator Eben.
In terms of parental rights, if I am a private school and I'm a parent, and I want my child to go to a private school where there's maximum health, similar to the way our chief executive's children go to school, where they have a mask mandate, this would deny that private school the right to have that mandate?
So what this bill does is it gives the right to the parent to make that decision on whether their child wears a mask or not, regardless of the environment or the situation.
So final question, just to be clear on the right of the parent. If I'm a parent and I want my child to be maximally healthy, my child, immunocompromised child, and I don't want them to come in contact with COVID if we can avoid it, and there's a group of other parents, and we have a school that is maybe a charter school even, and we want our children to wear masks to be healthy because they're immune compromised. This would allow another child who's possibly a carrier for COVID or COVID positive to come in and sneeze on them without a mask?
Senator Eben, what I would say to you is that you as a parent have the right to send your child to school with a mask on. And many people believe 100% that the mask will work, and they are taking whatever precautions they deem appropriate for your child. But other parents are not allowed to make those decisions for the students of other students in the classroom. What I would tell you is that most parents are not going to send their kids to school with COVID. That's not going to happen. And the private school has the right and the ability to turn that kid away from the school until they have fully recovered.
And just last thing I'll say, I don't want to take too much time, but I just want to say that unfortunately people don't always know if they have COVID is the problem, and this is a highly communicable disease that we're in the middle of a pandemic, or whatever you call it, a pandemic or an endemic. And I'm not suggesting that people intentionally would sneeze on them to do that, but I'm just saying that some people want to take health precautions, and that parents have a right to have their children in a healthy environment. That's all.
Mr. Chairman and Senator Eben, what I would tell you is that the private schools, public schools remain the right to send the kids home if they feel that they have a fever. There's a certain protocol that each school puts in place in that particular situation.
All right, are there other comments or questions? All right, I do have one, and that's that if you look on line 36, sort of start in the middle of the line, or is not wearing a face covering for the purpose of preventing transmission of COVID-19. So it seems to me that that in reality, what this would say that even if you didn't want to wear a mask or had difficulties, challenges in terms of wearing a mask, that a face shield, the type of thing that covers the face, in which a lot of health professionals wear on a regular basis, there would it be impacted there? So is that correct? So that you don't, that the public accommodation facility would not be able to say if you either don't or can't adequately wear a mask, that a face shield would not be an adequate substitute.
Mr. Chairman, respectfully, I would tell you that face covering does affect a number of the people that we talked about early. Not everyone can wear a face covering, even a face shield. Children, victims of domestic violence, children with developmental and intellectual disabilities, that would still be a challenge for them. And so this is to get away from the one-size-fits-all type of approach. And give more flexibility between the parents and the school system to try to work out a acceptable arrangement.
What I was
yes.
to
Right.
make sure we had options here.
Right.
And it wasn't just a mask. So
Right.
That this would not,
Right.
that there would be other things
Correct.
that could be done there. All right. Does anyone else on the committee have any questions or comments? All right. Is there anyone in the audience who wants to speak in favor of the bill? Yes. Come up. Please.
If you are in the Zoom room and would like to speak in
let's-
favor of the bill,
Okay. Huh? Okay. Yeah, go ahead and have them there, and you can go proceed now. So,
Mr. Chairman, my name is Darrell Bowe. I'm from Spotsylvania County, and I do support this bill. The reason why I support it is because I've actually experienced this with my wife. She's hearing impaired, and she wears hearing aids in both ears. And we have been told to leave at times because of the issues of me not wearing a mask. But in order for her to understand what I'm saying, she needs to be able to read my lips as well as the hearing aids. So she has personally experienced the discrimination at times of refusal of service and so on and so forth. So the mask issue, and with me as well, wearing a mask, I have reoccurring sinus infections because of the mask, so it affects my health as well. But most of the time I wouldn't even wear a mask just because I need to communicate with my wife because of the hearing impaired. And so I would hope that the Senate would support this bill to protect the rights of all people, those that are being discriminated against. We shouldn't have any kind of discrimination whatsoever against anyone. And so I would ask that the Senate support this.
all right, thank you. Thank you. Is there anyone else in the audience who wishes to speak? All right. The list of people that are.
Miss Marcia Lessard, you will be speaking first, followed by Miss Doris Nick.
Hi, somebody else popped on. Okay, my name is Marcia Lessard. I am the founder of Virginia Freedom Keepers. We oppose any and all one-size-fits-all mandates. This bill is absolutely essential so that you are not furthering marginalization of children like mine. I have a child who was injured by a vaccine. These blanket one-size-fits-all mandates are not for everybody, especially those of us who have children who have autism, sensory disorder issues. So Virginia Freedom Keepers, we have 20,000 members, and we have people in our membership that are each and every one of your constituents who are reaching out to us, begging that you enact these and several other medical freedom bills. These are your constituents as well. You represent all of us, and we're asking that you just give a choice. On top of that, on a personal issue, when I was 25 years old as a police officer, I was on a training mission and I was sexually assaulted. I was held down and I was suffocated. I'm on a full medical exemption right now at George Mason from masking because it triggers such intense PTSD issues that I can't function for several days. I was in Wegmans in Loudoun County and I had a stranger come up to me and physically assault me because I wasn't wearing a mask. It is absolutely essential that you enact non-discrimination policies. I understand your fears and I understand your concerns, but the right is to uphold my constitutional liberty to make choices with my body. And if you're wearing a mask and you believe it works, then you should feel safe. Thank you so much for hearing my testimony today.
All right, next.
Doris Nick, you are next, followed by Whitney Speed.
Hello, Senators. Thanks for your time. So I strongly support this bill because mask mandates are unethical, immoral, and unconstitutional. This does not A respiratory illness doesn't make any sense to obstruct your airways, to affect your respiratory system. And children's lungs are not even fully developed at this point. I've listened to 150 doctors speak on the fact that masks do more harm than good. So there is a lot of doctors out there that are just being censored, like Dr. McCullough, Dr. Robert Malone, Dr. Zelenko. There's the Great Barrington Declaration. Something that most people aren't aware of is they're an industrial hygienist. It's their job to properly fit people in masks. They come into hospitals and things as such. This is not happening anywhere. It's not happening in the schools. There are people right now currently walking around that should not be wearing masks for medical reasons, such as asthma, high blood pressure, heart issues, PTSD, and cancer. Those people should not be wearing masks, and that has been shared by an industrial hygienist. It's just wrong to children. It's physically, mentally, and emotionally abusive. My child is 7, and he has nightmares of people wearing masks. I do not mask my children, and I will not mask them. This is a personal discrimination issue. In Virginia Family Dentistry, I was denied entry, and I wasn't able to get dental care because I refused to wear a mask. When you sit down in the dental chair, they take off the mask. In fact, they work in your mouth. We are being discriminated against, those of us for religious and medical reasons, or if we just want to show our children that there's nothing to fear, that they can survive this with other options. It's unacceptable to force. It's already currently causing segregation, and I do hope and pray that you make the decision, because health, Senator Albin, health does not come from wearing a mask. It comes from your immune system, and you can strengthen that in many ways, by taking vitamins, by getting exercise, by getting sunlight, by not living in fear. We don't do this for every other illness, and there's no reason for us to be doing this now. Children are the least affected by COVID. Thanks for your time.
Thank you. Next.
Whitney Speed, please begin your testimony now, followed by Roger Vettinger.
Can you hear me?
Yes. Proceed, please.
My name is Whitney, and I want to testify in strong support of this bill. I personally cannot wear a mask for both psychological and physical reasons. I suffered tremendously from it, and it's been really, really hard the last couple of years to not be able to do any of the things with my kids that we've always done. And it's been really hard not to be able to go into places and to be afraid everywhere I go that someone's going to lose their mind on me because they can see my face. But when I put a mask on my face, it makes my head spin, it makes me dizzy. I nearly passed out one time trying to accommodate people who were upset and worried about seeing my face. And it's been absolutely miserable. And the state has responsibility to protect those of us who cannot accommodate everyone else's fear from discrimination. And thank you.
Thank you. Next.
Roger Vettenheimer, you are next, followed by Joe Billings.
Hi there, Mr. Chair and committee. My name is Roger Venteicher, and I'm speaking in support of this bill because while I was in the military, I was injured and have a traumatic brain injury from it. And from the brain injury, I now have a seizure disorder. The seizures are pretty much under control other than heat and stress. The stress is controlled. The heat, as far as when I put the mask on, I was almost 2 years without having a seizure before COVID hit. After COVID hit, I had 2 seizures while having a mask on. I now have 3 doctors with medical exemptions from not wearing the mask due to, 1, seizures, but also for PTSD because they put me in panic attacks because I'm scared I'll go into a seizure. Because I can't wear a mask, I am no longer allowed to go to my daughter's school to check her out. I can no longer go to any of her school functions that are held indoors, such as choir or anything else. I can no longer go to the school board meetings and speak about my daughter's education and to find out about her education. They say I can get on a computer and use that, but when the meeting's 6 hours long and you have a seizure disorder, you can't sit there and watch a screen that long. And that's all I have to say. Thank you.
Next.
Joe Billings, you are next. Mr. Billings, you're muted.
Can you hear me now?
Yes.
If you can hear me, I would like to speak in favor of this bill. I am a registered nurse. I am no longer working, but until recently, I spent 17 years working in the emergency department at VCU Health Center. I'd like to say that N95s are the only mask that is proven to occlude the virus. Short of an N95, it's like putting up a chain link fence to keep mosquitoes out of your yard. So I strongly agree with this bill. I have no problem if people want to wear masks. I don't feel that they're effective, and I don't feel that we should be coerced into putting on a mask unnecessarily. Only an N95, which is quite inhibitory, is effective.
All right, thank you. Is there anyone who wishes to speak in opposition to the bill?
If you're in the Zoom room and wish to speak in opposition to the bill, please raise your hand now. Mr. Chair, there are a couple speakers. Kripa Padwardian, you will be first.
All right, proceed.
Good afternoon, everybody. Thank you for having me. I actually was not intending to testify about this bill, but I am dismayed by the level of anti-mask sentiment that I've been hearing today. Masks saved lives. Several of my educator friends have gotten exposed to COVID, but because they wore a mask, they tested negative the whole way through. Masks save lives. Mask mandates are the reason that schools have been able successfully to resume in-person instruction. And I'm grateful for the last 2 years, I haven't gotten a cold or the flu or any winter bugs. That's because of the mask. Vaccines and masks save lives. I am dismayed to see calls to lift these mandates. Again, I wasn't intending to I was not intending to speak to this bill, but I needed to get that out. Thank you.
Naila Carroll, you are next. Ms. Carroll, please unmute.
Hi, members of the committee and chairman. My name is Nayeli. I speak against this bill. I have a daughter that has asthma. I know as a parent and of asthmatic child, she cannot wear the mask, but at the same time, I'm afraid the people who can help to protect the virus are not doing her part, and I'm not going to be available to send my child as much I want to the school. I don't have the privilege to take my daughter from public school to a private school and make sure that gonna help that to her education, and at the same time to help her to be safe. She have problems in the past, not only because of the virus, but like asthmatic person, she was getting really sick and not available to enjoy her life. we're wearing her a mask is kind of a little bit difficult, but at the same time, I believe that help her to be more healthy. I know it was a little difficult to her at the beginning, but with time, was helping her better in each day. And I really, I'm afraid that if this bill pass, instead helping her, gonna send her more to the hospital. And like I say, I don't have the privilege to take my daughter from public school to put her in private school and make sure that she's gonna be healthy there with people around that doesn't that wear a mask and protect other people.
All right.
I believe that this.
Thank you for your testimony.
All right.
Time is up, but thank you very much.
Miss Myra Sanchez, you are next. Miss Sanchez, please unmute and begin your testimony.
Can you hear me?
Yes.
Oh, good afternoon. My name is Myra Sanchez, and I'm against this law because I have issues. I'm a asthmatic person. I have issues. I'm a cancer survivor, and I'm a diabetic person. So I'm a kind of person who has a lot of risk. Without the mask, I feel myself so exposed to be sick. Actually, I already been sick twice. Once with COVID-19 and one with Delta on summertime. And even that I was covering myself. But you see, there is a lot of people out there who happens to be sick and doesn't show they are sick. And even where I work myself, I work in a flower shop, and I be pretty far from the people trying to get close to the places, and they cough and they sneeze and they leave everything in there. And being that way, it's been so hard for me to survive this time. So if we remove all these protections, I don't know how it's going to be the rest of the year if I try so hard to survive myself the way it is. And without that, it's going to be hard, very hard for me, and it's going to do a lot of harm on me. And I think I won't afford it to pay no more bills to the hospital. Thank you very much.
All right. Is there anyone else to speak? All right. Senator Chase, you want to sort of wrap up things? So.
Thank you, Mr. Chairman. And
Certainly.
I also want to thank those who spoke for and against the bill. And it really does show the diversity and thought about whether to wear a mask or not to. And this bill really gives people the freedom. If you want to wear a mask, if you want your child to wear a mask, they have that right. They have that right. Parents who see it as an issue for their child, they have the ability to make the choice not to wear the mask. Those who have extenuating circumstances, disabilities, it allows us to take into account all of those situations and allow individuals to make those choices for themselves. Mr. Chairman, I would say it's time to save face. It's time to give people the freedom to breathe and give them the freedom to choice. Thank you.
All right. Thank you. Is there any, the bill's before us. Does anyone have a motion to make or comments? Senator Eben.
Thank you, Mr. Chairman. I would move to PBI.
All right, there's a motion to pass by indefinitely. All right, and a second to that. Is there further discussion?
And Mr. Chairman, if I could please to clarify to the members who are tuning in that a PBI means they're going to pass by the bill indefinitely, ultimately killing the bill. So a vote yes is to kill the bill.
All right, the motion is before us. Let's vote on the board.
Ayes 8, noes 6.
All right, ayes 8, noes 6. That bill is not reported.
Thank you.
All right.
Ready for my second bill?
Yes. Yeah.
All right. Thank you, Mr. Chairman. My second bill is Senate Bill 548.
That's all right.
Senate,
I'm messy.
Senate Bill 548, basically many people are familiar across the country with something called vaccine passports, and we see it in other countries. We're starting to see it here in Virginia and other states, and I'm trying to be proactive to make sure that we don't discriminate against people who make a conscientious decision not to get the vaccine. We need to respect people's individual rights and choice. This bill prohibits discrimination and public accommodations on the basis of an individual as having received in part, or not received a vaccine for the prevention of COVID-19. Virginians today can shop, travel, and live without being asked to provide documentation on whether they are up to date on their immunizations, such as measles, mumps, rubella, or polio. Yet in 2022, Virginians are being asked if they have received the COVID-19 shot, and in many cases denied entry into doctors' offices, restaurants, places of business, and even employment if they do not answer in the affirmative. In fact, if you don't answer in the affirmative, they assume that you haven't. This is egregious and a complete violation of an individual's right to privacy. It's not their business. This bill is to ensure Virginians cannot be denied goods and services because they refuse to disclose their health care status to someone who is not even in the health care industry and has no business knowing what shots any Virginian has or has not taken. As a result, Virginians are being denied health care services, food, and participation in everyday life. This discrimination has to stop. Virginians must not be denied food, health care, transportation, or participation in society because they refuse to get the jab. While many of the childhood vaccines that have been around since the late 60s have virtually eliminated these known illnesses, the COVID shot has not stopped the transmission of COVID. In fact, those that receive the vaccine are still contracting COVID and still spreading the virus. Why then is the COVID shot being treated as a vaccine when in fact it is not? And in fact, the CDC actually changed the official definition of vaccine almost a year after the COVID-19 vaccine was created. That occurred in September of 2021. The COVID-19 vaccine is not infallible. In fact, there's still many breakthroughs. At first, Virginians were told that if they got the COVID-19 vaccine, they wouldn't have to wear a mask. And so many did. Now, over a year later, vaccinated individuals are still contracting COVID-19. Once, and even twice, happened to my own daughter. And in fact, in addition to wearing a mask, vaccinated individuals are recommended and even required in some cases to receive additional booster shots. This has led to much skepticism even by people who have been vaccinated. I remember running into a lady on the airplane who sat beside me who said, I was vaccinated, but I identify as someone who wasn't vaccinated. She actually had no prior cardiac issues and experienced a heart attack after receiving the vaccine. In addition, Virginians all know of loved ones who have received the COVID-19 vaccine and died with days. And I have a testimony of someone here in the committee today to share her testimony. As a result, many Virginians do not want to get the COVID-19 vaccine. It's a conscientious objection. Why are we denying goods and services, proper health care, and participation in life when the COVID-19 vaccine has not proven as effective as other more well-known childhood vaccines? Virginians everywhere are frustrated. The COVID-19 vaccine was not the cure that we had hoped for, But there are other options and other treatments that are made available in other states and other countries like monoclonal antibodies, ivermectin, and hydroxychloroquine. Why should businesses, employers, governments, and colleges be able to dictate or mandate a one-size-fits-all approach to combating COVID-19 when there are other options? That decision should be left to the individual. Thankfully, on Thursday, January the 13th, the Supreme Court blocked the Biden administration from enforcing its sweeping vaccine or test requirements for large private companies, sending a message that mandating vaccines is a step too far. We must not allow Virginians who choose not to be a part of the great experiment to be discriminated against because they choose not to participate. Virginians deserve the right to choose their own destiny. James Knox Polk was the 11th president of the United States, serving from 1845 to 1849. He previously was the 13th Speaker of the House of Representatives and the 9th Governor of Tennessee. He was a protege of Andrew Jackson, and he was a member of the Democratic Party and an advocate of Jacksonian democracy. And he said, "We must ever mandate the principle that the people of this continent alone have the right to decide their own destiny." Virginians want to be given a choice on whether or not they get the COVID-19 shot. The Virginia Department of Health should educate, not mandate. Let's protect the right of Virginians to make these health care decisions for themselves. Thank you, Mr. Chairman.
All right, thank you. Are there any questions from members of the committee? All right. Is anyone in the audience wishes to speak in favor of the bill? All right, come forward again.
Once again, my name is Darrell Bowe, Mr. Chairman. I am in support of this bill. A statement just coming out from the United Kingdom. Prime Minister is making an announcement that they're going to end the COVID vaccine passports and mask requirements in United Kingdom. Czechoslovakia, the Prime Minister ends vaccine mandates. We do not want to deepen the rifts in society. So right now we're seeing countries overseas, large demonstrations by the hundreds of thousands that's been going on for several weeks to end the mandates, to end the vaccine mandates, to end the mask mandates, because you're segregating our society, you're separating us, and you're discriminating against us. We need to end this now. Boston is doing the same thing. They're having protests. They're being discriminated against because they're not allowed to walk into a restaurant because they can't show a vaccine passport. This is discriminating against the people. We have rights, and we have the right to go where we want to go, when we want to go, and we should be able to receive any type of service at any time. These are the rights that each and every one of us should be able to exercise without discrimination. This is a clear, blatant discrimination by mandating vaccine passports. We don't need it. Foreign countries are already starting to drop it because they see the loss of services, the loss of businesses, and it's only going to just divide us even more. So I support this bill.
Thank you. All right, you want to check to see whether anyone...
If you're in the Zoom room and would like to speak in support of this bill, please raise your hand now.
Yeah. All right, come forward, yeah.
My name is Heather Piles, and I'm here to support this bill. Back in July, my aunt had recently got remarried. She moved to Florida. Her husband, who was a doctor in the Navy, basically gave her the ultimatum, you can get the vaccine or we can't travel. So she couldn't come home to see her family unless she got this vaccine. Upon getting this vaccine, she made it in home, time to get in touch with her family. And my last message from her was, can you come by here and record my story to make sure that no one else takes this vaccine? She was covered, her whole body, with blood clots. I was supposed to go record her on a Friday. I told her I was on my way at 1:30. She let me know that she was too tired. That night she was in the hospital. By the end of the week, she was dead. No one should be forced to do something that they do not want to do. And we are Americans, and we should have each other's back, and we should be supporting each other. And I just watched Virginia send a very clear message that they are tired of the tyrannical government that we are witnessing, putting all of these mandates on us, and we are sick of it. So I hope that you will pass this bill. Protect our freedoms.
Thank you. All right. People on the Zoom.
Marsha Lessard, you are first, followed by Doris Nick.
Hi, thank you. Again, I am the founder of Virginia Freedom Keepers. We have over 20,000 members that want the freedom of choice. We could argue all day long about the safety and efficacy of vaccines. The VAERS system, which only captures 1% of all vaccine injury and death, tells you just in its mere existence that vaccines are not safe for all individuals. But if we get to the point, this bill is not about whether you believe vaccines are safe and effective. This bill is about, do you believe people should be discriminated against or not based on their medical or religious beliefs? If you believe in people's freedoms, if you believe in religious beliefs, if you believe in the fact that these doctors have granted medical exemptions for people like my son who almost died from a vaccine, then you need to affirm, whether you like the person who brought the bill forward or not, that you do not believe in discrimination today. The world is watching in Virginia right now. We are seeing what's happening in my county, Loudoun County, and we're watching this. A vote for this bill shows you do not believe in discriminatory practices, and it sets your ideologies about a liability-free product aside. Do you, senators, believe in discrimination or do you not? Do you believe in marginalizing people who are medically and bio-individually different than you are? Do you believe in discriminating against people who have different religious beliefs than you? That is what this bill is about. It is not about your belief in a liability-free product. It's about discrimination. And I hope to see your votes accordingly. Thank you.
Thank you. Next.
Doris Nick, you are next, followed by Whitney Speed.
Hi, Doris Kinnick here. I'm going to back up what Marsha said. I agree as well. Medical apartheid is just as evil as racial apartheid. I want you to think long and hard about who owns our bodies. Do we own our body or does the government? Discriminating against someone in any workplace is against the U.S. Constitution. It's against Title III of the U.S. Civil Rights Act, which prohibits discrimination based on medical condition, i.e. unvaccinated, in private businesses such as grocery stores, banks, restaurants, hotels, retail stores, and all public facilities, including schools. It's also against the Virginia Constitution, Article 1, Section 1, which protects our personal rights and states that all people are by nature free and independent and have inalienable rights. Among those are enjoying and defending life and liberty, acquiring possessions and protecting property, and pursuing and obtaining safety, happiness, and privacy. All persons within the jurisdiction of the state are free and equal, no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status are. They are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. Please stop this medical apartheid from occurring in any longer in Virginia. It's the same thing with the masks and children. It is not about equity when you are discriminating against those who are vaccinated and unvaccinated. This is immoral, unconstitutional, and just incredibly wrong. We have got to stand for freedom and freedom of choice from a product that is the manufacturers are not liable for. This is a conflict of interest since 1980 with the Bob Dole Act, known as the Patent and Trademarks Law Amendment Act, and when Congress granted scientists and federal agencies and universities the right to claim personal ownership of inventions. What do we think Fauci's up here doing? He's making a big money from this. I encourage everyone to read The Real Anthony Fauci by Robert F. Kennedy Jr. And please vote for this bill. Stop this discrimination of COVID vaccines. Thank you.
Thank you.
Whitney Speed, you are next, followed by William League.
Hi, I strongly support this bill. 15 years ago, my infant laid in my lap and nearly died from a vaccine reaction. He turned blue, he had a seizure. It was vicious, and he was sick for months afterward before he had any level of recovery. Within a few years, 2 of my nieces and 1 of my nephews also had severe adverse reactions to vaccination. After 4 of our children had their lives threatened by this type of medicine, we determined that this was not a good type of medicine for our family. And I don't want the world to be shut down to my children, to not be able to go half of the places or all of the places because someone initiates a vaccine passport. It's dangerous. There's no such thing as a risk-free medical decision. The only person capable of determining the value of risk to me is me, with the guidance of my physician, who knows all the details of my medical history. The clerk at Home Depot, my boss, my son's teacher, none of them are qualified to judge my medical needs or those of my children. Because bodily autonomy is the most basic human right, we have to protect the citizens' rights to make the best medical decisions for themselves with the guidance of their physicians and no one else. Thank you.
Mr. William League, it is your time. Mr. William League, please unmute and begin your testimony.
Okay, I'm here. Can you see me? Can you hear me? It says it's muted.
Yeah, we can hear you. You can let us know what your testimony is.
Mr. League, you're muted.
All right. How about now?
Now you're good, so thank you.
Okay. Good afternoon, Mr. Chairman and members of the committee. My name is William League. I'm here today in support of Bill SB 548, which would prohibit discrimination in public places based on vaccination status. I was a pharmacist for CVS for the past 9 years. I'm in the process of being terminated as a pharmacist because I did not take the vaccine. I did not make this decision lightly. I made this decision after my stepdaughter was on a ventilator for 12 days in the ICU due to COVID. We were that family. We kept a constant vigil outside the hospital, and she survived and is doing well. But during this life-changing time, I began research into COVID-19 and its origins, and the complex geopolitical and economic considerations surrounding its development. I began to compare treatment protocols the hospital was using with suggestions from the Frontline Critical Care Alliance. I became familiar with the works of Luc Montagnier, Christine Northup, Joseph Mercola, Mike Adams, Robert F. Kennedy Jr., David Martin, Project Veritas, to name a few. I continued working as a pharmacist with serious concerns over the safety and efficacy of these inoculations. I hurriedly filed a religious exemption that was denied and have repeatedly been denied an appeal, even though the appeal includes a letter from my pastor and evidence of the effectiveness of early interventions for COVID. I'm left with no other recourse but to begin anew, finding a job as a farmhand with no vaccine requirements, growing the very food that this legislation will deny access to. I look back on the near decade of service to CVS and wonder, was it all worth it? The long hours and time spent away from my family, only to have my loyalty rewarded with an early termination because I refused a shot.
All right, your time is up. Please wrap it up quickly.
Okay, let me end finally with a word about the safety and efficacy of the vaccine. Any pharmaceutical product dispensed in the pharmacy is required to have a package insert, which includes the ingredients, administration consideration, adverse reactions, and special precautions in at-risk population. The Pfizer product in pharmacy freezers includes no such information. the FDA approval was manipulated to be misleading. Evidence is emerging globally that the shots may be contributing to cardiomyopathy, immune dysregulation, thrombotic events, i.e. strokes, cancers, and even death. There are even videos of electron microscopy showing a single drop of the Pfizer product lysing and depleting the body of hemoglobin, red blood cells, which deprive the body of oxygen.
Thank you for your testimony. Thank you.
Got one final statement, sir. I consider it a violation of the Hippocratic Oath to do no harm to continue to administer an experimental vaccine to patients that have not been provided informed consent, given the current level of censorship and misinformation.
All right, thank you. We need to move on. We got several things, other things to do, but thank you for your testimony. All right. Want to just sum up just quickly here. So.
Thank you, Mr. Chairman. I appreciate your patience. I just want to leave you with one final thought. Dr. Robert Malone, he invented the mRNA technology, which has been used to create the Pfizer and Moderna COVID vaccine. He's been speaking out about the dangers of the COVID shot, such as the damages that coronavirus spike protein causes in the body. In this interview with Dr. Bigtree, Dr. Robert Malone calls for a stop of COVID vaccines. Finally, he explains that the COVID vaccine can cause enhanced immune response, which creates a worse reaction when exposed to the natural coronavirus. He says that it can create autoimmunities in the body. Mr. Chairman, I appreciate you all, your patience. I know we have very mixed thoughts on vaccines, but I do believe that we need to respect the individual rights of individuals who make those decisions for themselves. Once again, vaccine passports discriminate against people who make a conscientious decision not to be disrespectful to their neighbors, but out of a conscientious objective to their family and to their situation. And for that reason, Mr. Chairman, I would ask that you all would pass the bill. Thank you.
All right, the bill is before us. Is there? Yes.
Comment. I would just say, another angle of this is you cannot have somebody have to report medical information or the lack of that information without impinging upon their privacy rights. And having a threshold where you have to show verification of a vaccination or explain to a restaurant owner why you have a medical exemption is above and beyond any expectation of HIPAA or privacy. And, there's an opportunity for us to inspire people to get the vaccination and accept that there's a patient's bill of rights and that they have the power to make their own decision. But we shouldn't be using this as a litmus test to get into stores. And so for that reason, Mr. Chairman, I'll move to report.
Second. All right, we have a motion and a second to report. All right, there's no further discussion. Let's vote on the motion.
Ayes 7, noes 8.
Motion fails.
Thank you. That was a long bill. Thank you all for being so patient. Thank you.
All right, you want
I'd like to make a motion.
a motion from Senator Evans?
I just want to say I do respect the passion that the witnesses brought and feel that there are some who have individual circumstances, but I think there is something about societal good and private property rights to protect their workers. But I understand this is a complex issue, and I don't think that this bill will solve the problem of while still protecting. And I know that when you go to elementary school, you have to show that you had a polio vaccine. That's different than going to a restaurant or a store, as Senator Donovan would point out. But with all due respect, I'm going to move that we PBI the legislation.
And Mr. Chairman, if I could just clarify to those that are listening in that a PBI would mean that they would kill the bill. That's what a PBI is. So if you
All
vote
right.
yes.
Yeah, we have a
it's to
motion
kill
for a
it.
second. Huh?
It's already reported.
Oh, Okay, so okay.
No motion. Thank you.
All right, we'll try the motion
Thank you.
then. All right, thank you.
Thank you.
Thank you.
Mr.
All
Chairman?
right.
Mr. Chairman?
Yes.
Having voted on the prevailing side of SB 95, recommend we reconsider. I have notified the patron, and he has said to proceed.
All right, so there's a motion to reconsider the vote on Senator Norman's bill. Is there a second to that motion? Second. All right, all in favor of reconsidering, vote on the board. All right,
Ayes 13, noes 2.
Ayes 13, no 2. All right, then the bill is back before us.
Mr. Chairman, having Senator Norman explained the bill previously, I move that the bill pass.
The patron's not here to speak to the bill?
The patron is not here, but I had Senator Bell contact him, and the patron said to go ahead without him being here. So
Mr. Chairman, yeah, I did contact him, ask him if he wanted us to hold till he was here. He said go ahead and proceed, that he had explained it.
All right.
Mr. Chairman,
All
I
right,
renew
there's a
my
motion.
motion to report the bill, barring
Motion
any
to
questions.
report. All right. Motion to report, and there is a second. Any further discussion? All right. Then we'll vote on the board. So.
Ayes 6, noes 9.
All right. Ayes 6, noes 9. All right. Motion fails to report. All right. Then Senator Lewis.
Well, Mr. Chairman, members of the committee, I'm afraid my little Senate Bill 533 is going to be disappointing to you.
So, it depends on how long you take to explain that disappointment.
Not long at all. Not long. Mr. Chairman, members of the committee, Senate Bill 533 came to me really at the request of the Virginia Realtors, who were requested by the Board of Realtors at DPOR to put in some legislation or to codify a clearer understanding of realtors' escrows and escrow and how deposits are held. So you see what the bill does, two things. In the paragraph 1, it says that if a realtor is to hold the escrow, that it will be placed in the realtor's escrow account within 5 business banking days. Further, it adds section 2, which says if the realtor or the principal broker is not to hold the deposit as per the contract, that it will be delivered to the escrow agent that's in the contract within 5 business banking days. So apparently what was happening was realtors who were not actually in possession because of the board's regulatory policies, realtors who were not actually in possession of the escrow check, who had passed it on to an attorney or a title company, were often being held responsible for inadequate handling of the escrow check, whether it wasn't deposited timely, whether it was kept in a file, something of that nature. So what this seeks to do, again, at the request of the Board of Realtors, is to clarify the responsibilities of the broker or the realtor with the escrow, with the deposit in the escrow account and the firm's escrow account, and also with passing it on to the designated escrow agent. So that's the bill.
All right. Are there any questions or comments from members of the committee? All right. Is there anybody wishing to speak who's in the audience who wishes to speak to this in favor of this bill? Yes.
Mr. Chairman, Aaron Barton with the Realtors. Just want to thank the Senator for bringing this very boring technical bill that will hopefully help clear things up for the Real Estate Board, and I'm happy to answer any questions anyone might have.
All right, thank you. All right, you want to check?
If you're in the Zoom room and would like to speak in support of this bill, please raise your hand electronically now. There is no one wishing to speak in support.
All right. Wait a second. I want to see if there's anybody in opposition, since that's the way you're doing it. So.
If you are in the Zoom room and you would like to speak in opposition of this bill, please raise your hand electronically now. There is no one wishing to speak, Mr. Chair.
All right. All right, we got a motion and a second to report. Well, we had the second first, but what can I say? So, all right, if there's no further discussion, let's vote on the board. So, yeah.
That's 15-0.
All right, 15-0.
Thank you,
All
Mr.
right.
Chairman. Thank the committee.
Thank you very much, and thank you for your patience. So, all right, well, we will now have bills from members of the committee. Let's start with Senator Boysko.
Thank you, Mr. Chairman, members of the committee. Today I have SB 444, which it's an agency bill allowing departments, agencies, and institutions of the Commonwealth to convey easements to telecommunications companies for telecommunication lines, including broadband. And as I said, this is at the request of the Virginia Department of General Services. Right now, they are able to convey right-of-way easements over property owned by the Commonwealth for the purpose of building infrastructure for electricity, telephone, cable, television, water, gas, steam, and sewage. But despite Virginia's push for universal broadband coverage, these agencies cannot convey easements for the purpose of that. We've made incredible progress. I serve as the chair of the Broadband Advisory Council. This is something that's important. And I have Sandra Gill from the Department of General Services here to speak to the bill.
All right.
Mr. Chairman, Senator Reeves. Mr. Chairman.
Yes, Senator Reeves.
Can you just define telecommunications for me, companies, what that entails?
I am looking here to see if we have a definition for it. I'm hoping that Sandra is here to clarify.
I'm assuming it's an internet or broadband
Yeah,
based.
the intention is that.
Okay. Thank you.
All right. Is there anyone in the audience who wishes to speak in favor of the bill? All right. You want to check to see if there's anyone online?
If there's anyone in the Zoom room that would like to speak in support of this bill, please raise your hand electronically now. There are no speakers electronically, Mr. Chair.
Okay. Yes, go ahead.
Chair, members of the committee, Sandra Gill, Department of General Services. I apologize, I was up the hill. We appreciate Senator Boysko carrying this bill for us. It's simply to allow for easements for broadband, and it's just very technical in nature.
All right. Let's see if anybody's opposed.
If you are in the Zoom room and would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there is no one wishing to speak.
All right, we got a motion and a second to report the bill. We can proceed now to vote on the board.
Let's go. Sorry. That's 15-0.
Well, I'm glad there's no one standing in the way of broadband, so. Yeah. All right. Senator Ruff, you want to present a bill?
Thank you, Mr. Chairman. Senate Bill 183, and I have a substitute for that I would ask you to adopt.
Move the substitute.
Second. All right, motion and a second to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. All right, the substitute's before us.
Mr. Chairman, the bill before you is in order to strengthen the cemetery board ability to protect the public in situations in which cemetery company's license is revoked. This is to ensure that maintenance is continued. This clarifies how the board will seek receivership to assume that maintenance. The entity that is appointed to be the receiver will maintain and be paid a reasonable fee set by the court from the assets of the cemetery company. Since I'm not prepared to move into a cemetery at this time, we have Mike Dowdery from the Cemetery Association on the remote, I believe, that would be willing to speak or answer any questions.
All right. Are there any questions or comments from members of the committee? All right. Want to see if there's anyone who would like to testify in favor of the bill.
If you are in the Zoom room and would like to speak in support of the bill, please raise your hand electronically now. We have Mr. Michael Dury, and he will speak first. Mr. DeHurtley, you can speak now.
All right, Mr. Doherty, you can speak now.
Okay, Mr. Chairman?
Yes.
Members of the committee? I'm a longtime legislative chairman of the Virginia Cemetery Association and an 18-year former member of the State Cemetery Board. Some for-profit cemeteries are required to be licensed by the board, and there have been several occasions when a cemetery was so bad that the board had to revoke their license. When that happens, the board loses jurisdiction and power over the regulant. But with a cemetery, you can't just lock the door and close up shop. The cemetery is still there. Bodies need to be buried, memorials and gravestones need to be installed, and the grounds need to be maintained. So it should be mandatory that a receiver be appointed when a cemetery company license is revoked, so that the local circuit court, through its receiver, can see that the cemetery ends up in good hands. Thank you.
All right, thank you. Is there anyone who wishes to speak in opposition to this bill?
If you are in the Zoom room and wish to speak in opposition, please raise your hand electronically now. Mr. Chair, there are no speakers.
All right, we have a motion and a second to report. Any further discussion? All right, we'll vote on the board.
Ayes 15, no 0.
All right, that is reported. Do you have another bill? All right, other members of the committee who have a bill, who wants to go?
Senator Barker.
Senator Locke? Yeah.
You ready?
Did you call me Senator Barker?
All right. Senator Locke.
Okay, I think we have it now.
All right. Oh,
Okay. I have Senate Bill 153, and I have a substitute.
Move the substitute.
all right, substitute. Do we have copies of the substitute, or?
It's online.
It's going to be posted online momentarily.
Okay.
And the substitute does not have any substantive changes. There just corrects some drafting errors.
All right, Senator Locke, you want to proceed?
Yes. Mr. Chair, this bill establishes the Secretary of Diversity, Equity, and Inclusion, which was a position that was established by Governor Northam, and it removes the position of Director of DEI and simply elevates it to a secretariat position, and it reassigns the duties of the director to the secretariat's position. And so in 2020, the legislation was introduced. The position of Director of Diversity, Equity, and Inclusion was set in code. And this simply is requesting that be moved from director to secretary.
All right, are there any questions or comments from members of the committee?
And I believe that Governor Youngkin has announced an appointment to the position of DEI, a director of DEI.
All right, Senator Evan.
Thank you, Mr. Chairman. I know usually the cabinet secretaries have agencies that report to them, and under this, I see that there's someone for New Americans. Does this move any agencies to report to that secretariat?
I believe the Office of New Americans was with the director of DEI. And that would be working directly with this secretariat.
Thank you.
All right. Any other comments or questions, committee members? All right. Anyone in the audience wish to speak in favor of this bill?
If you are on the Zoom and wish to speak in favor of this bill, please raise your hand electronically now. Mr. Chair, we have one speaker, Ms. Janice Underwood.
All right. All right. Proceed, Ms. Underwood.
Good afternoon, Mr. Chairman.
Thank you.
And members of the committee. My name is Janice Underwood, and I'm the former Virginia Chief Diversity Officer for the Commonwealth of Virginia. It was truly an honor to serve 8.5 million Virginians in this historical role, and that made Virginia a national exemplar for innovation and transformation, especially as we were able to thread inclusive excellence in our COVID-19 response and recovery, which has been lauded as a best practice, by the way, by the National Governors Association to all states. DEI has never lived at the intersection of government and politics before, and as a result, the work of the Office of DEI has gone largely misunderstood, and I'm elated to learn of the new DEI officer appointed today by Governor Youngkin, which shows us that this work is bipartisan. So today I'm speaking in favor of Senate Bill 153 as a resident of Virginia and national DEI thought leader who knows how to drive diversity-led innovation and policymaking in support of opportunity for all. One of the statutory obligations per the Virginia Code that I followed was to turn feedback into concrete policy. Therefore, I laud the leadership of Senator Locke because this bill is a result of hearing from thousands of state employees, faith leaders and clergy, leaders in the corporate sector, leaders among various stakeholder groups like the NAACP. And it was the priority recommendation from all of the public reports of the governor's constituency advisory boards, including those that serve the African American community, the AAPI community, the Women's Council, Latino and Hispanic communities, and the Virginia Office of the New Americans Advisory Board. And by the way, every member of the Historic Health Equity Working Group of the COVID-19 Unified Command. Even the private sector from major consulting corporations have published reports in support of strengthening the DEI infrastructure of organizations such as McKinsey, Deloitte, and others. And this bill just does that in just a smart way. My second statutory obligation was to create a statewide strategic plan to advance DEI innovation, and the One Virginia mission and vision, which created the foundation for the first statewide plan to advance that kind of innovation, is a bipartisan, if not nonpartisan framework that has been embraced and championed in speeches from both parties, including in Governor Youngkin's executive order for his Chief Diversity, Opportunity, and Inclusion Officer. I'd like to underscore that our society has placed an emphasis on DEI across national accrediting bodies. So if Virginia wants to be competitive, we will need to build upon the DEI infrastructure to continue to be a leader, like CNBC's Best State for Which to Do Business, continue to have all of our higher education programs nationally accredited to meet these DEI standards and DEI metrics that have been built in to ensure that we serve all of our diverse residents. So I strongly support this bill. It's a simple technical amendment. It's already a cabinet position across both parties, and I'm happy to answer any questions. Thank you.
Is there anyone else who wishes to speak in support of the bill?
Mr. Chairman, there is no one in the Zoom room that wishes to speak in support.
All right. Is anyone to speak in opposition?
If you're in the Zoom room and like to speak in opposition of the bill, please raise your hand now. Mr. Chairman, we have one speaker, Ms. Vic Nichols.
All right.
Ms. Nichols, please begin your testimony.
Thank you. Actually, the small reason I'm against this bill is I think Dr. Underwood did an outstanding job as she was placed in it and really took the ball and run with it. I'm very grateful for what she did. And I would like to see that this stays with one person. My concern is sitting here and looking and going, are we going to get a whole bunch of people that come into and want to do other things and stuff like that and build up stuff with it? Frankly, Dr. Underwood did outstanding by herself, and I'd like to see it as just one person only, not with a bunch of other people, and that's the reason why I'm against it. Thank you.
All right. Anyone else in the audience to speak? All right. If not, okay, we have a motion to report. Is there a second? And actually, the motion needs to be to report and re-refer to finance. The motion needs to be to report and re-refer to finance. They've asked for it. So, all right, we got that motion. Is there a second? Second. All right, we have a motion and a second to report and re-refer to finance. If there's no further discussion or questions, then we'll vote on the board.
Ayes 9, noes 4, abstentions 2.
All right, thank you. That is reported and re-referred to finance. All right. Senator Hashmi, you can sprint up here again. So.
Thank you, Mr. Chair. I have two bills.
Okay.
The first is SB 263.
All right.
And this is a bill that is coming from our Joint Commission on Healthcare. The purpose of the bill is to just expand the existing Housing and Support Services Interagency Leadership Team to now include older Virginians as a target subpopulation in current housing initiatives. This legislation was a unanimous recommendation from the JCHC following a staff report that assessed Virginia's current programs and services would enable older Virginians to age and place safely in their communities. So the report found that one of the greatest unmet needs for older Virginians is affordable housings. Older Virginians make up 22% of the population, but account for 44% of low-income, rent-burdened households. The Housing and Supportive Services Interagency Leadership Team is a collaborative team that's led by DHCD, and it was established to aid in the creation and implementation of the agency's goals that would increase permanent supportive housing for people with intellectual and developmental disabilities, people with serious mental illnesses, and people experiencing chronic homelessness. So this bill language now adds that we would also add or include older adults now as a target subpopulation.
All right. Are there questions or comments from members of the committee? All right.
Mr. Chairman?
Yes, Senator Evans.
And I apologize to the patron if I didn't listen closely enough, but did you say that this was a recommendation of the Joint Commission on Healthcare?
Yes.
Okay, I'm sorry I missed that.
All right. Are there any questions? All right. Does anyone in the audience wish to speak in favor of the bill?
If you're in the Zoom room and wish to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Ms. Vic Nichols.
All right.
Ms. Nichols, please begin your testimony.
Thank you. I would like to thank Senator for putting this up. It's very much appreciated. And the fact is, people, once they get older, problem is they have trouble getting jobs. Right there, that's going to be a big issue when it comes to needing support services. And definitely targeting them would be very much appreciated. Thank you, Senator Hashmi. Appreciate you. And hopefully that you would watch out for our seniors and go ahead and approve this bill. Thank you.
All right, thank you. Is there anyone who wishes to speak in opposition to the bill?
If you're in the Zoom room and wish to speak in opposition of the bill, please raise your hand electronically now. Mr. Chairman, there is no one wishing to speak.
All right.
Mr. Chairman,
Yes.
Mr. Chairman, just one quick thought. I think it's a great bill. We've got a couple that we're addressing some elder abuse that came from the VCJC, and I don't know what that acronym is, but it's the Criminal Defense Lawyers and the Defense Lawyers. Yes, sir. And we were looking at standardizing the vernacular, and you say older Virginians, so maybe we should look at shoring up some of those things just to define what that means, because at this point in the committee, I feel like an older Virginian, but I don't know what would qualify, and so maybe we just think about making sure that it's saying the same thing in all parts of the code, because we're trying to clean that up. Thank you, Mr. Chair.
Qualify you.
I would never say that about Senator Ruff.
All right. Anyone want to make a motion on the bill?
Second.
All right, a motion and a second has been made to support the bill. Report it. If there are no further comments or questions, we'll go ahead and vote on the board.
Ayes 14, no 0, 1 abstention.
All right. Your next bill.
Thank you. Yes. Thank you, Mr. Chair. The second bill is SB 270, which is concerning language access in the Commonwealth. I'll share just a little bit about the origin, one of the origin points for this legislation, and it was through the work of the newly founded Virginia Asian American Pacific Islander Caucus. Last spring, we held a series of town halls, listening sessions across Virginia. And one recurrent point that we kept hearing from so many folks that live in the Commonwealth is that language access was a clear and important impediment to their ability to access resources and to gain services that they critically needed, particularly during COVID. Information about housing, information about unemployment benefits, information about education for their children, and it was a point of serious concern for many of our families. This particular legislation is seeking to create an interagency language access working group that would work across our agencies within our state government. So the work group would establish and maintain a model language access policy that should be used by all of our state agencies. It would develop and update a glossary of common terms so that we are consistent across our agencies, and also translate necessary and vital information to at least 10 of the most frequently spoken non-English languages across the Commonwealth. We also would like to have the language access coordinator within each state agency. This would be someone who is already employed within that agency to have that responsibility to track the progress that's being made, and also to recommend policy changes and to support a report to the governor and the General Assembly every November. This is such a critical need. Again, as I said, we've heard from so many of our constituents about the need to provide adequate language access, and that this would be an important service that we would be able to follow, a first step to just helping so many families become better integrated and have better access to critical and vital resources that our state government provides. And I think we have many folks who are wanting to speak on this particular legislation.
All right. Are there questions or comments? Senator Evans.
Very briefly, just want to thank you for the bill and suggest that as this goes forward, if it goes forward, that we remember to include the court system with it, because I know our different court circuits, at least in Northern Virginia, there are some materials that are available in certain languages, some that are not, to make it easier for people to know what's going on in the court system. And I think they benefit from this as well.
Thank you very much. And I should also mention that this is not just for non-English speakers, but also for Virginians with disability who need that similar language access.
All right, is anyone in the audience who wishes to speak in favor of this bill?
If you are in the Zoom room and wish
Come
to speak
forward.
in
We
support of this
have
bill,
someone to speak here
please
now.
raise your hand electronically now.
Mr. Chairman and members of the committee, thank you for letting me speak on this important topic today. My name is Christian Martinez Lemus, an advocacy specialist for CASA, and we provide services to more than 10,000 Latino, immigrant, and working class Virginian members. CASA is in support of SB 270 as it will give trust to our immigrant community and non-English speakers when it comes to using Virginia state agencies. For recent CASA data gathered from the past 370 community members that visited the Woodbridge Welcome Center, we saw that 71.35% were beginners with their English. That is 264 community members who are learning. This is an example of the inequalities in access to governmental system navigation. We must invest in our English language learners. Let's look out for our Virginia neighbors and pass this bill.
Thank you. Anyone else wish to speak?
Mr. Chairman, we have multiple digital speakers.
Okay.
Patricia, you will speak first.
No, I want to speak against the bill, but I'm in the wrong spot here.
Okay.
Thank you.
Lang Liu, you will speak first.
Hi, thank you. My name is Ha Tang. My mom is Sang Lo. She will be speaking in Vietnamese, and I'll let her start first. Hi, members of the committee. Hi. Yeah.
Xin chào các chị nghị sĩ Việt Nam. Tôi tên là Lan Lu. Tôi sống ở Sterling, quận của Center Boy Co. Tôi ủng hộ SB 270. Nếu chúng ta có quyền truy cập ngôn ngữ tốt hơn thì dễ dàng thuận lợi hơn. Xin chào.
Thank you. Thank you. I will translate now. Hi all, my name is Ha Tang. Thank you, Senator Hashmi, for presenting this. I would like to say I am part of Humke Center, and my mom, as you see, is a Viet speaker. What she said was, hello, members of the Senate of Virginia. My name is Lang Liu. I live in Sterling, district of Senator Boysko. I support SB 270. With this bill, it would be better for us because to have better language access and easier for us to communicate with people. Thank you.
Monica Samamito, please begin your testimony. Sheila Varkey, you will be next.
Good afternoon, members of the committee and Mr. Chairman. Thank you for having me here. My name is Monica Sarmiento, and I'm the Executive Director of the Virginia Coalition for Immigrant Rights, a collaborative of 45 organizations in the Commonwealth. Virginia is home to the 9th largest population of the immigrant community in the United States. Language access is absolutely crucial for so many communities across the Commonwealth. We are here on behalf of the 45 member organizations and fully support SB 270. Thank you, members of the committee.
All right, thank you. Next.
Sheila
Good afternoon, Mr. Chair. Sheila Varkey from Virginia Poverty Law Center. We are also in support of this bill to help people gain access to state agencies and their services with language access plans, language coordinators, as Senator Hashmi described. And I want to just bring attention to something that Senator Evan asked about in terms of including courts. While this bill is about state agencies, the Department of Juvenile Justice runs the Court Services Unit intake program at the JNDR court. So effectively, if a person asked for a protective order, and we heard stories, especially during the height of COVID, about Spanish-speaking petitioners seeking protective orders and being told by intake they would have to bring their own interpreter with them. So effectively, this is the Department of Juvenile Justice acting as a gatekeeper for people to ask for emergency protection from the courts. So this is just one of the reasons we support this bill. Thank you so much.
Thank you. Next.
Chloe Edwards, please begin your testimony. Freddie Mija, you will follow.
Hello, members of the committee and Mr. Chairman. My name is Chloe Edwards with Voices for Virginia's Children, where our mission is to improve the lives of Virginia's children. In 2019, the Commonwealth Institute for Fiscal Analysis reported that roughly 212,000 people in Virginia do not speak English or do not speak English well. Voices for Virginia's Children reported that 1 in 5 children in the state speak a language other than English, and 44,000 children may require language access services. So while Virginia is becoming more racially and culturally diverse, the state is not keeping up to pace to ensure that we reach every resident. Inequitable language access has life or death consequences. Title VI of the Civil Rights Act of 1964 states that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial services. So this applies to intentional or unintentional forms of discrimination, including administrative methods that may affect people because of their national origin. In 2021, the Virginia Department of Health published instructions for English readers stating that COVID-19 vaccine will not be required for Virginians. However, the Spanish language translation conducted through a Google translation, which it stated, no será necesario, or the COVID-19 vaccine will not be necessary. So the incorrect translation actually stayed up for a month on VDH's website. Many states have passed laws to increase access to language equity. In fact, at least 43 have enacted laws across the state of Virginia. So we hope that it pleases the members of this committee to support this bill and do the same. Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Freddie Mejia with the Commonwealth Institute and the Healthcare for All Virginians Coalition. We support this bill because it will allow more people in Virginia to fully understand and access health coverage options, thanks to coordinated and uniform language access across all state agencies. The following organizations have also signed on in support of this bill: Birth in Color, Mental Health America of Virginia, Virginia Organizing, New Virginia Majority, National Multiple Sclerosis Society, Virginia Breast Cancer Foundation, Virginia Interfaith Center for Public Policy, Virginia Hemophilia Foundation, Virginia Association of Free and Charitable Clinics, RX Partnership, Virginia Poverty Law Center, American Lung Association, Virginia, and the Virginia Association of Community Psychiatric Nurses. Thank you, and I ask that you report this bill.
Zoe Aquino, please begin your testimony, followed by Kripa Padawan.
Good afternoon, Mr. Chairman and members of the committee. My name is Zoe Aquino from Humke Center, which organizes with Asian American Virginians across the Commonwealth. And I'll keep my remarks brief today. We support SB 270 because all Virginians deserve to communicate and understand the information they are presented, regardless of their English proficiency or ability statuses, especially when navigating Virginia state agencies. So thank you so much, Senator Hashmi, Mr. Chairman and members of the committee, and we ask you to support this bill today. Thank you so much.
Kripa Padawan, it is your time to speak.
Good afternoon, everyone. My name is Kripa Patwardhan. Thank you for having me. I'm here both as an immigrant myself and speaking on behalf of Edu Futuro, a nonprofit that has been in existence for the past 24 years. It's based in Northern Virginia. Its mission is to break the cycle of poverty in immigrant communities through educational support. Our beneficiaries are from all over the world and represent 61 different countries of origin. And a sizable percentage, if not most, of Edu Futuro's beneficiaries they speak a language other than English. They're English language learners. And the communities that we serve, they were disproportionately affected by the COVID pandemic last year and continue to be. It wasn't only because of the higher risk of infection and adverse outcomes, but because they were less readily able to access government resources that would have offered relief because of language barriers and cultural barriers. SB 270 would mitigate this inequity dramatically, and to that end, Edu Futuro strongly supports SB 270 and urges every member of the committee to vote yes on SB 270. Thank you very much for your time and consideration today, and I hope you all vote yes.
Mr. Chairman, that is the last of those wishing to speak in support.
All right. Do we have one person speaking in opposition?
Yes, sir. We have 2 individuals wishing to speak in opposition. Anyone else who also wishes to speak in opposition, please raise your hand now. Ms. Patricia, it is your time to speak.
Oh, thank you. Can you hear me? Can you hear me?
Yes, we can hear you.
Oh, good. Okay, thank you very much. I'm in South Arlington here. I have a couple of questions. Now, there were 10 languages that you wanted to emphasize. And I know that for voting in the state of Virginia, mail-in voting is translated into Korean and Vietnamese. So I want to ask, what are the other 8 languages?
I'm chair of the committee, and I don't have that information, but I could guess on some of them. But
Is this public testimony or Q&A? That's my question.
So.
Well, if you can't answer the question, that's all right. I'll go on with some more thinking here. As an English-speaking Virginian, I would like to be able to learn all these other languages. And I think it ought to be offered to me for free. If I, as a taxpayer, am being asked to pay for all these other people to have things translated into English. That's thought number 1. Number 2, since many English-speaking people don't know these other languages, the gap between accurately translating what happens could be very important, as the lady who was speaking Spanish said. You know, the difference between you're required to have a COVID injection or you're not required. And there's a month's time there. So I would ask that the Webster Dictionary be the standard for English. I would ask that English be the standard in the state of Virginia. And I would also like to share that on my block, when I go up to people who do not speak English and start to talk to them in English, they say to me, no comprendo. And I have news for you. They don't want to learn. That's all I have to say.
All right, thank you.
Ms. Nichols, please unmute and begin your testimony.
Thank you. I want to share a little bit of a concern about that was spoken by Ms. Arlington, because here's the issue. Definitely when somebody has maybe been here a year or 2 or something like that, you know, that definitely I could see some of this. But my concern is once they've been here a while, 5, 6 years or more, to be able to sit there and honestly assimilate to the point where we can share cultures and things, and that we can get them to move up. English, you're going to have to be proficient in English to be able to get a number of jobs and stuff like that. I'm concerned that this kind of would, if you're not forced to do some of that and be able to learn enough English to speak, and like I said, move up. We want to make sure the higher up in education, things are taught in English here. And definitely that's where the issue is more of, you're going to come here and be a part. English is part of that as much as I would expect to learn French if I went to Canada, or Spanish if I went to Mexico, and be fluent enough after a period of time, you know, a year or 2, to be a part of that culture. That is the only concern that I have with this. Thank you.
Thank you. All right. I don't think there's anyone else to testify. So the bill's before us, and go ahead. All right. Motion to report. All right. Motion and a second to report and re-refer to finance. If there's no further discussion, we'll all vote on the board.
Ayes 8, no 6. Ayes 8, no 7.
We have a malfunction here.
I was hitting it really hard. You can just you can vote me now. It's fine. Thank you.
All right. That is the bills are reported. So
Thank you, Mr. Chair.
All right, Senator Bill, or Senator McPike, Senator McPike, sorry. Yeah.
Thank you, Mr. Chair. Senate Bill 225.
All right.
So what this bill does is helps to refine the architectural engineering section of the procurement code to simplify and raise the threshold to $10 million for a total contract value and limit to not to exceed $2.5 million. As you can see in the existing code, there's multiple sections that have different thresholds. This helps to actually clean it up. It raises the threshold. There's general wide consensus of helping clean this up and simplify this section of the code. And happy to answer any questions, Mr. Chair.
All right. Are there any questions or comments? All right. Anybody from the audience wish to speak in favor of the bill?
This is the last one you get.
Mr. Chairman, members of the committee, I'll start by answering Senator Reeves' question. But Patrick Cushing with Williams Mullen. I represent the American Council of Engineering Companies and the American Institute of Architects. One of the reasons why we're here with this bill this year is I think you've seen me a number of times on bills related to term contracts, which are ways that public bodies procure A&E services for small jobs. For big jobs, those are requests for proposals looking for the most qualified firm. The term contracts are meant to bring 5 or 6 firms on at one time to address small projects from a public agency. And so this code section has been chopped up over the years. We've seen public bodies want to raise limits and change how these work. So what we did is developed a bill that we thought would hopefully be good for all or most public agencies, and hopefully that's this bill. We've been working on it all summer and involved a lot of stakeholders, so this helps simplify the code section. I think, so we've got, I'm just going to show this. This is a matrix of all the different agencies with different dollar thresholds and terms and all that type of stuff. 7 different buckets. And so if you take away and do a clean draft of this bill, if you're not looking at the bill as amended, what you're going to end up with is a matrix that looks like this. Everybody's under the same rules. So that's what we're trying to do, and we support the bill.
All right. Next.
Chairman, members of the committee, Bill Hefty, representing the Virginia Association of Governmental Purchasing. We support the bill because it simplifies it and makes it easier for procurement people to administer.
Thank you. All right, is there anyone else to speak in favor of the bill?
If you are in the Zoom room and wish to speak in support of the bill, please raise your hand electronically now. There is no one in the Zoom room wishing to speak in support.
All right, see if there's anyone who wants to speak in opposition.
If you are in the Zoom room and wish to speak in opposition of the bill, please raise your hand electronically now. There is no one wishing to speak at this time, Mr. Chairman.
All right. All right, we have a motion and a second to report the bill. If there's no further discussion or questions, we can vote on the board.
Ayes 14, no 0, 1 abstention.
All right.
Thank you, Mr. Chair. The second bill is Senate Bill 607. It looks like, I don't know if Senator Stewart wants me to speak on this one with another abstention, or we'll see, but. So this bill is, as a result and follow-up in some collaboration, the NFPA had a report this previous year noting that house fire fatalities, 3 out of 5 homes did not have a working home fire alarm actually working. So the rate of fatalities, even though we've had devices and technology in place for decades and decades, there's still sort of a persisting problem throughout the United States. So this is sets out Section 1 bill to have the Board for Asbestos-Lead Home Inspectors to designate sort of what is the good working order. So if you're going through and walking through right now, you can say, yes, there's one. You don't necessarily have to say it works. And so it sort of leaves it to the board to then help to better define what is good working order to help increase, frankly, life safety across the Commonwealth. Happy to answer any questions.
Mr. Chairman.
Yes, Senator Reeves.
Jeremy, is this going to make sure that they press the button so it goes beep, or batteries? Is that basically it, or are they going to promulgate things that say it's got to be an alert system going to monitored? You know what I mean? I'm just worried that they might get too far gone.
Yeah, I think the basic idea is hitting the button, but I know Andrew with Home Builders has done some work in outreach and collaborating with others on this in development.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia. The intention, this came out of some conversations with fire marshals and builders about ways to just address a surprisingly high number of homes that are unprotected. The intent was just to have a home inspector, instead of just visually inspect that it's there or not there, just press the button. And that's kind of the thinking behind sending it to the board, so that the professionals would be able to develop the regulations themselves and the language to actually implement it. So just taking it one step further, push the button.
All right. Is there anyone else to speak in favor of the bill?
If you're in the Zoom and would like to speak in favor of the bill, please raise your hand electronically now. There is no electronic speakers.
Mr. Chairman, Rob Bohannon with Hunt and Andrews Kurth, representing the Virginia Association of Real Estate Inspectors. No position on the bill, but appreciate what Senator McPike and all are trying to do. And to answer Senator Reed's question, we work greatly with the asbestos-led and home inspectors board. I've talked to them about this. Want to make sure too that it's not something, because one of the truths is the only way you can really test a smoke detector is with smoke. But there are ways, working with the board, we feel like on other regulations, there's a way we can come up with something that's workable for everyone and doesn't put too much burden on the home inspector.
All right. Yes. Yes, Senator Stewart.
While I believe that we really have devolved into regulating the minutia, I have a bigger concern that I would ask Rob. If a home inspector goes in and presses the button and it beeps, as the Senator suggests, or if it doesn't and they change the batteries, and then the house catches on fire and the alarm doesn't go off, is that home inspector now liable? Could they be sued? Is there a cause of action for that?
That's, Mr. Chairman, to answer Senator Stewart's question, that's probably a better question for an attorney. I think that's why the board would look at this issue and figure out, because I don't think they're trying to put more burden on top of a home inspector either, but that's what we'd want to make sure didn't occur in that process.
Seems to me
because they're snapshots in time, right? A home inspection is a snapshot of that.
It seems to me that would create a cause of action as a.
Mr. Chairman, that'd be no different than today, that someone comes in and inspects your HVAC unit, you buy the house and you get a CO leak, right? There's many different dangers as you buy a house today that is already a part of our construct. And so there's many different aspects of a home. This is one component of it that I don't see draws any different cause of action based on any other inspection that you have today. You have natural gas, you have CO, you have radon, you've got many other things that could cause harm to an individual that exist today.
All right. Is there we got a motion and a second to report. If there's no further discussion, we'll vote on the board.
Ayes 12, noes 3.
All right. Senator Bell, I think you're the last show for today.
Thank you, Mr. Chairman. Sorry, I'll just go in numerical order. So start with 258. You'll see 258 and 259 are pretty similar.
Okay.
258 is a bill that it does a couple things. It raises the threshold on that contractors are required to submit a bid on bid bonds, and this raises it to $500,000. Right now, there is a little bit of confusion because there's different bond thresholds for certain type of transportation projects at $250 and non-transportation at $500. Just puts them all at $500. Also, the pre-qualification process for non-transportation is between $100,000 and $500,000, specifying when no bond is required. So this is a little bit cumbersome, and it just eliminates that pre-qualification mandate for these smaller projects. So it just really tries to clean up the code and have consistency and recognize that we heard this on earlier testimony about the cost of materials and goods, and inflation's happen, and this higher threshold will actually ease the process for many of our localities. With that, happy to answer any questions. I don't know that we have any opposition to this, and I have people, I think, who are ready to speak. Maybe.
All right. Are there questions or comments from members of the committee? All right. Want to come forward and testify? So,
Bill Hefty, Virginia Association of Governmental Purchasing. We asked for this bill. This statute has gotten confusing over the years, and these are small contracts. We just want to clarify for procurement people to make it easier that for projects over $500,000, you have to have a bid bond. For projects under $500,000, it's optional. Thank you.
all right. Thank you. All right. Is there anyone in the Zoom who wants to speak either in favor or opposed?
If you are in the Zoom and would like to speak, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. All right. We got a motion and a second to report. If there's no further discussion, we'll vote on the board.
Ayes 15, no 0.
We let you vote on that one.
Pardon?
We let you vote on that.
Oh, thank you. I appreciate it. I wondered if it was him just shutting me out. Just because he can.
Yeah. Next, 259.
Thank you, Mr. Chairman. This is very similar. This bill is performance and payment bonds for public construction contracts. And again, it gets rid of the inconsistencies. In this one, in case some of the this thresholds are set at 350, some are 500, it moves them all to 500, and it really tries to clean this up. It also fixes the setting on projects exceeding 500 in the regards to the pre-qualification process. So it eliminates this mandate for smaller projects, which I think is, again, very helpful to many localities and for bidders. This is something it's really just an inefficiency bill as well.
Yes, Senator Eben.
Thank you, Mr. Chairman. For Senator Bell, I'm just curious, did someone ask that this bill be brought? Was it, and have you consulted with VDOT at all? Or people who would be issuing the procurement? It's the same.
You want to talk?
Yeah. Senator, we have discussed it with VDOT, and so they're aware of it, haven't indicated any opposition. We've also talked to the Association of General Contractors and the highway people, lobbyist Gordon Dixon, and they haven't seen any problems with it.
Thank you.
I would just add, from a VDOT perspective, this would be an incredibly small figure for a VDOT type project. So.
All right. Was there anyone else to testify on this?
If you are in the Zoom room and would like to speak in support of the bill, please raise your hand electronically now. If you are in the Zoom room and would like to speak in opposition of the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. We got a motion and a second to report. If there's no further discussion, vote on the board.
Ayes 14, no 0. Ayes 15, no 0.
All right.
All right, the last one is a bill you may recall. We've done this one before. It actually was a bill, this is SB 461, and it's on licensure of on-site operators of boiler and pressure vessels. This one, I actually carried it at the request of the Apartment Association. Also, this was the one that was requested by the National Association of Power Engineers. And they wanted to establish a voluntary licensure program. The idea here is these boilers, if they're operated incorrectly, they can explode. It can be very dangerous and hazardous. So it's to make sure that, is there a Mr. Chairman, didn't move that. Can I move the substitute, please?
Substitute, all right, we got a substitute, okay. All in favor of adopting the substitute, say aye.
Aye.
All opposed, no. All right, the substitute is before us.
Thank you. So back to it, we requested this. We went, at their request, we developed this legislation, passed last year 10-zip at this committee, and was forwarded. The only reason we didn't enact it is Department of Professional Occupational Regulation, DPOR, created a work group to study it. They felt like, especially with COVID at the time, we should hold off on it. The work group actually came up with the language that we've used in this piece of legislation. So very minor tweaks where we're at. That's where we're at today, Mr. Chairman. Like I said, I think this is the third time we brought this, and last year it would have been enacted. But given the situation we're at with everything, we held off. So we've looked at it again. We think we have peace in the valley. I don't know of any disagreements on this, and I'm before you. Answer any questions you may have. And I do believe we have people possibly online for this.
All right, are there any questions or comments? Senator Evan.
Yeah, thank you, Mr. Chairman, for Senator Bell. Are all the boilers inspection reports still filed with the Department of Labor and Industry? Does this have anything to do with that at all?
Mr. Chairman, it would not relate to that. It's more related to the operators of that equipment. So it's more about not the equipment. License. Yeah, their license. Are they trained and are they qualified to adjust or to work on that equipment?
I thank you.
Yes, Senator Stewart.
Senator Bell, what is a hot water heating boiler not exceeding 100 boiler horsepower? Can you just explain? I just want to make sure that the guy who's working on a boiler in somebody's home does not fall under this.
I'll call a friend in a second, but the bottom line is this would be more of an industrial unit. In a home unit, it would be typically people would either have oil type heat, natural gas type heat, and in some cases even electric heat. That would not be the kind we're talking about. This is a boiler which would use typically steam and pressure to create enough heat generation for a larger facility. So not your home type, more of an industrial. Does that?
Mr. Chairman,
yes,
some of us have old homes, and they have old boilers in them, or for that matter, new boilers in them, and radiator heat,
Yep.
and people we like that work on them, and I don't want to exclude those people from working on them. I get why you want to do it for an apartment building, and I'm all with you, but I don't want to exclude the small service technicians who do a good job.
Mr. Chairman, we don't want to do that either. It's voluntary, if you read it in the legislation. And we also have gauged where it typically, unless you have a really big unit, it would not be applicable.
All right. You want to testify in favor?
Sure.
Sure.
I'm going to slide this out of the way a little bit. Sorry. All right, Mr. Chairman, members of the General Laws and Technology Committee, my name is David Ferrara. I live in Fairfax, and I'm the CEO for the NAP Educational Foundation. I'm here in support of Senate Bill 461. I was here January 22nd, 2020, and I didn't get to speak until 6:06 p.m. So while this might seem like a long day, we're actually making some pretty good timing here. That bill passed unanimously with one exception, and she's not here right now, so hopefully her proxy will hit the yay button, because Senator Bell's right now batting 1,000. Let's see if we can get him through the day like that. Unfortunately, this was held up, as Senator Bell mentioned, due to the opposition from DPOR, which has been resolved through the work group that they led. During my testimony 2 years ago, I referenced several catastrophic boiler explosions that had taken the lives of boiler operators and civilians. One that I pointed out killed 5 people when a boiler exploded. That boiler traveled half a mile, had 11 seconds of hang time, and killed several people, including a husband and wife and the HR professional they were meeting with on their first day of work. Since I was here last, there's been many other events that have caused boiler explosions. This is due to improper boiler operations, lack of maintenance, and other reasons. Just 6 months ago in Strasburg, Virginia, a boiler explosion resulted in an ammonia leak that took 7 hours to get under control by the fire department. Luckily, nobody was near the boiler when this happened, as nobody was even there. In this instance, the boiler shot out of the back of the building and flew into a shopping center behind it. It left a hole in a consignment shop wall just 5 feet from the water main and 10 feet from the electrical main coming into the building. That store was closed for a month while the store was repaired. 14 hours after the explosion, the fire department turned over control of the site to a hazmat crew. As you can see, this could have been much worse had it not happened so early in the morning, or if the explosion sent the boiler just a few feet in either direction. Different. I believe that passing Senate Bill 461, we can take a huge step towards protecting the citizens of Virginia. In addition to the safety benefits, there are economic benefits as well. Studies show that job-specific certifications can increase pay by up to 50%, which may result in increased state tax revenue for Virginia. Virginia will not be alone in requiring this license. 10 states, the District of Columbia, and over 30 cities in the U.S. currently have boiler operator licensing requirements. Please help us protect the citizens, the property, and the integrity of this great Commonwealth by voting to approve this bill. I stand for any questions you may have, and thank you for the opportunity to submit my testimony to this committee.
Thank you. All right, is there anybody? Okay, we got another person to speak, okay.
Yep, Mr. Chairman, members of the committee, my name is Bisma Ahmed, representing the Apartment and Office Building Association and the Virginia Apartment Management Association. We echo the comments of Mr. Ferreira and ask that you support this bill, please. Thank you.
All right, anyone online?
If you are in the Zoom room and wish to speak in support of this bill, please raise your hand electronically now. There are no speakers wishing to speak in support. If you are in the Zoom room and would like to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
Move to report.
All right, we got a motion and a second to report the bill. If there's no further discussion, we'll vote on the board. Oh, wait, does this need to, this needs to go to finance, so.
Amend the motion to report and refer.
Second.
All right, voting for the amendment of the motion, say aye. Aye. All opposed, no. Okay, that's before us as being both. So, all right, we'll now vote on the board.
That's 15, no zero.
Thank you, Mr. Chairman.
Certainly. All right. If there's no further business,
Is that it?
we're done.
You gotta have more than that.
It's not even 6 o'clock. What do you mean? So,